大家繼續保持肅立。
相信大家係早2日收到一個令人沉痛嘅消息，鑑於我哋前國家主席江澤民先生喺11月30日因病逝世，為表深切哀悼，我哋而家將會進行默哀1分鐘，以悼念江澤民先生。To mourn the passing of the former President of China, Mr. Jiang Zemin, we will respect a minute of silence right now. 請各位就座，接下來我哋會正式進入今日會議嘅開幕儀式。
再一次感謝大家今日出席由香港基本法教育協會主辦、香港城市大學法學院、浙江大學國際戰略與法律研究院、一帶一路國際研究院香港世界貿易組織研究中心以及上海對外經貿大學法治與國家治理研究院協辦，慶祝香港回歸祖國25週年一國兩制與一帶一路的倡議國際法律論壇。現在我哋即將舉行一個簡單而隆重嘅開幕禮啟動儀式。我哋有請梁美芬主席陪同以下嘅主禮嘉賓移步台上。首先恭請中央人民政府駐香港特別行政區聯絡辦公室陳東副主任。
香港特別行政區立法會主席梁君彥 GBM GPS JP。
繼續有請中華人民共和國外交部駐香港特別行政區特派員公署方建民副特派員，有請。
香港特別行政區政務司副司長卓永興 GBS JP， 有請。
繼續有請前香港特別行政區律政司司長、最高人民法院國際商事專家委員會委員、香港國際仲裁中心聯席主席袁國強 GBM SCJP， 有請。
全國人大常委會香港特別行政區基本法委員會副主席委員譚慧珠 GBM JP。
繼續有請前香港特別行政區律政司司長梁愛詩 GBM JP， 有請。
前香港特別行政區立法會主席范徐麗泰 GBM GPS JP。
我哋再次以掌聲歡迎我哋在座我哋喺台上咁多位嘅主禮嘉賓，亦都多謝咁多位喺百忙之中抽空出席。
請大家喺搖桿前準備，我哋一齊數1、2、3之後，我哋一齊拉下個搖桿。
好啦，我哋而家請大家單手放上去我哋嘅把桿上面先。咁大家準備好，我哋一齊數3聲咯喎！預備1、2、3。慶祝香港回歸祖國25週年，一國兩制與一帶一路的倡議國際法律論壇正式開始。請我哋台上咁多位主禮嘉賓繼續留步，我哋一齊影一張嘅合照。請大家望望我哋中間嘅大會攝影師。請我們台上的各位主禮嘉賓先看看我們中間的大會攝影師，我們先拍一張合影。再一次感謝我哋台上咁多位主禮嘉賓。由於梁君彥立法會主席以及卓永興政務司副司長公務繁忙，我哋先以熱烈嘅掌聲恭送兩位。再一次感謝梁君彥立法會主席以及卓永興政務司副司長喺百忙之中抽空嚟到我哋當中為我哋主持開幕禮。唔該晒。
我哋係再次感謝我哋各位嘅贊助單位，包括新鴻基地產代理有限公司。
我哋亦都唔該晒咁多位我哋嘅台上嘅主禮嘉賓。現在咧，我哋會進行合照嘅環節嘅，都有請梁美芬主席啦，同埋我哋剛才咧為我哋進行儀式嘅嘉賓咧，亦都可以參與我哋台上嘅合照。我哋仲有幾張嘅合照嘅。咁呢張合照咧，我哋會邀請贊助單位咧同我哋嚟到台上合照。咁我哋有請梁美芬主席啦，同埋我哋剛才咧咁多位嘅儀式嘅主禮嘉賓咧，都可以再次嚟到台上。咁我哋咧移動好個主禮台啦。咁我哋都邀請大家可以再次嚟到台上。我哋咧仲有幾張嘅合照想邀請大家嘅。係，有請梁美芬主席同埋我哋咁多位嘅主禮嘉賓咧，可以再次嚟到台上。我哋有幾張嘅合照咧，想邀請大家合影嘅。
而家再一次介紹我哋嘅贊助單位，咁我哋各位派翻我哋嘅代表上台啦。首先係新鴻基地產代理有限公司、
東維亞集團國際有限公司、
薛博賢先生、
一帶一路總商會、
立橋人壽。
大家聽到你哋嘅代表嘅名，你哋嘅公司名之後咧，都可以移步派代表嚟到台上合照嘅。孖士打律師行、
謝青海行禮、
香港機場管理局、
李偉斌律師行、
匯蝶公益有限公司、
馬佳音先生、
鄧佑才先生、
李振升先生、
黃永光先生、
社區脈搏、
黃英豪律師、
馬豪輝律師
以及郭德亮先生嘅。咁大家聽到你嘅公司名或者你個名呢，都可以移步到台上，同我哋台上嘉賓影一張嘅合照。有請咁多位。好，各位嘅贊助機構嘅代表咧，都可以嚟到我哋台上啦。亦都非常之感激我哋嘅贊助機構嘅代表，因為咧有我哋咁多位嘅贊助機構，我哋今日嘅會議先至可以順利咁樣完成嘅。咁我哋有請我哋咁多位嘅贊助商可以嚟到我哋台上，我哋一齊影一張合照。好，大家可以望一望我哋中間嘅大會攝影師。好，我哋可以靠得親密少少啦。我哋再一次以熱烈嘅掌聲，感謝我哋台上咁多位贊助機構嘅代表。好，唔該晒咁多位贊助機構，大家可以先到台下就座。咁我哋咁多位主禮嘉賓請繼續留步，主禮嘉賓請繼續留步。我哋下一張嘅合照呢，會邀請各個嘅支持機構嘅代表嘅。咁我哋有請各大支持機構。咁除咗有香港律師會啦，同埋香港大律師公會之外，我哋兩個主要嘅支持團體呢，我哋仲有28個法律界嘅支持團體對我哋今次論壇支持嘅同埋贊助嘅。咁我哋先請香港律師會以及香港大律師公會嘅朋友，可以先嚟到台上，我哋一齊嚟到台上，去到我哋嘅主禮嘉賓旁邊先。亦都有請我哋28個法律界嘅支持團體呢，亦都可以派代表嚟到台上。我哋有請香港律師會同埋香港大律師公會，同埋我哋咁多個28個法律界嘅支持團體，都可以咧移步嚟到台上，我哋一齊影一張大合照。我哋有非常之眾多嘅支持單位嘅代表啊，大家咧要靠得再親密少少啦。
Could everyone squeeze in slightly together? There's quite a lot of you.
我哋咧有非常之眾多嘅支持單位啊，咁所以咧大家可以靠得親密少少嚟影我哋呢張合照啦。Yeah, let's get closer. We have so many sponsors and supporting organizations joining us on stage, so let's get closer for a group photo together. 好，之後咧請大家可以望一望我哋中間嘅大會攝影師啦。
Can everyone focus their attention to the cameraman in the middle?
Let's move a step to your left. A step forward to your left. 係啦，我哋向左邊有一步。好，大家可以望望我哋中間嘅大會攝影師。我哋再一次俾掌聲，我哋台上咁多位支持機構嘅代表。Thank you all for supporting organizations。多謝。咁我哋支持機構代表可以先回到台前就座啦。So the representative from our supporting organizations, please be seated。下一張嘅合照呢，我哋邀請香港基本法教育協會咁多位嘅理事嚟到台上。呢一張嘅合照呢，我哋都係人才仔仔嘅，邀請咁多位香港基本法教育協會嘅理事，大家都可以移步嚟到台上，我哋一齊影一張合照。咁我哋今日嘅論壇主辦單位呢，就係香港基本法教育協會啦。咁所以呢，呢一班嘅理事呢，亦都係非常之落力啦，幫手呢為我哋籌組咗今日呢一個嘅活動嘅。咁而家呢，都邀請咁多位可以嚟到台上同我哋一齊影一張嘅大合照。好，咁都邀請咁多位嘅理事，我哋可以望望中間嘅大會攝影師。好，我哋再一次俾掌聲，我哋台上咁多位理事，辛苦晒大家，唔該晒。請大家咧可以先回到台前就座啦。亦都感謝我哋咁多位嘅主禮嘉賓。今日咧，我哋咁多位主禮嘉賓都係喺百忙之中抽空出席蒞臨我哋嘅論壇，參與我哋嘅開幕儀式嘅。再一次感謝咁多位，亦都請大家可以先行就座。
OK， 而家再一次請主辦單位香港基本法教育協會主席兼全國人大常委會香港特別行政區基本法委員會委員兼香港特別行政區立法會議員梁美芬博士 SBS JP 上台。
Let's welcome Dr. Liang Mei-Fan, member of the Hong Kong SAR Basic Law Committee of the National People's Congress Standing Committee, member of the Legislative Council of HKSAR, to deliver an opening remark for us.
Honourable guests, Chief Executive Mr. John Lee, Deputy Director of Hong Kong and Macau Affairs Office Mr. Wang Linggui, Vice Director of Central Liaison Office Mr. Chen Dong, President of Legislative Council Mr. Andrew Leung, Deputy Commissioner of the Office of the Commission of the Ministry of Foreign Affairs of People's Republic of China in the Hong Kong SAR Mr. Fang Jianming. Dear friends, ladies and gentlemen, on behalf of the Organizing Committee and the Hong Kong Basic Law Education Association, welcome you all to come to Hong Kong and join this conference. I'm honored to host this prestigious event in this 25th anniversary of Hong Kong, returning to our motherland. The topic of this conference is One Country, Two Systems and the Belt and Road Initiatives. Since 1997, we started to organize such a scale of international conference on One Country, Two Systems and the Basic Law per 10 years. Many people are of the view that when we talk about one country, two systems, only constitutional issues may be covered. However, if one truly understands the Hong Kong SAR Basic Law, as well as the birth and implementation of one country, two systems, one will easily realize that the objective of one country, two systems is to let Hong Kong continue to play an international role and a key role in the world. which cover both social, political, and economic, as well as international perspectives. Let me take this opportunity to tell our international friends that after 25 years of practice, one country, two systems has been proven to be a world model for peace. It is not only a good thing, a good system for Hong Kong and Macau people, but also for 1.4 billion Chinese people, especially during the process of rapid development of China in the past 25 years. This has been affirmed by a paramount leader, Mr. Xi Jinping, in his speech on 1st July this year in Hong Kong. As the Hong Kong-born person, experiencing the whole process of handover in 1997, I dare say, one country, two systems is not only good for China, but also good for the world. History teaches us that in the process of decolonization often brings bloody wars. Hong Kong's peaceful handover back to China was a successful ratification of a historical wrong out of wars. In 1997, the capitalist system of Hong Kong had obvious and major difference with the socialist system of the mainland of China. One country, two systems was created as a pragmatic and practical solution while showing the generosity and tolerance of the Chinese political system. Imagine, without one country, two systems, whether the process for Hong Kong and Macau returning to our motherland would still be peaceful. And what would happen then for our region and the world? While benefiting from the backup of our motherland, the Pearl of the Orient remains a unique system preserving many of our characteristics, such as a capitalist system with a common law jurisdiction, low tax with free economy, free currency, as well as being a bilingual region serving both the English-speaking and Chinese-speaking world. This newly created system on Earth once experienced some difficulties, both economically and politically. But we went through it courageously. Hong Kong always ranks in the front as the world's freest economy and in the Rule of Law Index. This year is also the 9th year of China launching the Belt and Road initiatives. It reflects an effort of the Chinese government to open up to our neighbors, exploring more cooperative mutual enhancement opportunities, sharing development experiences for friendship and maintenance of peace. The recent 20th Working Report of the Chinese Communist Party emphasized our role of multilateral mechanisms such as the World Trade Organization and APEC, expand the influence of cooperation mechanisms such as the BRICS and the Shanghai Cooperation Organization, and enhance the representation and voice of emerging market countries and developing countries in global affairs. I was one of the earlier youth from Hong Kong who went to China to seek for my dream. Witnessing the rapid growth and changes of China from a country of poverty to an economic power, she experienced pains and successes, of course. But I can say the Belt and Road Initiative will further bring unprecedented opportunities for the development of China and our neighboring countries today. Trade is indispensable for cooperation and coordination between the professional community, including the signing of contracts and commercial agreements. It can be seen professionals from all walks of life must cooperate. It is comparable to China during the reform period and opening up period 40 years ago. And the promise of President Xi in the 25th anniversary to maintain one country, two systems to be a long-lasting system will definitely enhance this pearl of the Orient to flourish and shine brighter. COVID pandemic has blocked many of us from seeing each other, but no more. This conference is a little effort to bring all our friends, locally and internationally, to come back to Hong Kong, to meet each other, to see Hong Kong in person and enjoy it. Many of our guests from overseas are revisiting Hong Kong for the first time after this long COVID horror. Welcome back to Hong Kong. Let's join hands to restart our machine to work together for our next project, academic, professional, and business. Welcome back. Thank you.
再一次多謝梁美芬主席嘅致辭，請回到台前就座。接住落嚟，我哋有兩位主禮嘉賓嘅致辭，將會以視像嘅模式向大家致辭嘅。現在我哋首先恭請香港特別行政區行政長官李家超 GBM 致辭。
We will now have some pre-recorded speeches from a few honourable guests. The first one will be the Honourable John Lee Ka-chiu, Chief Executive of Hong Kong.
Distinguished guests, ladies and gentlemen, today's conference is a meaningful one on the one country, two systems principle, the Belt and Road Initiative, and contemporary international law. I would like to start by expressing my gratitude to the Hong Kong Basic Law Education Association, particularly Dr. Priscilla Leung, Chair of the Association, for the tireless efforts in promoting the understanding of the basic law and the rule of law, which are the bedrock of our society and development. This year marks the 25th anniversary of Hong Kong's return to the motherland and the implementation of the one country, two systems principle. Throughout the past 25 years, Hong Kong has thrived under this innovative principle with great success. As stated by President Xi Jinping in his important speech on July the 1st, one country, two systems is a good policy that must be adhered to in the long run. The President also encouraged Hong Kong to dovetail itself with such national strategies as the National 14th Five-Year Plan and the Belt and Road Initiative. Hong Kong has a robust legal system, a solid foundation of the rule of law, and a highly regarded judiciary that exercises its judicial power independently. Without doubt, these factors give Hong Kong a unique edge, allowing us to act as an interconnecting bridge between our country and the rest of the global community, in law, in business, as well as in other areas of cooperation and collaboration. Launched in 2013, the Belt and Road Initiative is well recognized as one of the largest platforms for international cooperation around the world. It brings about historic opportunity in our country's development, and Hong Kong endeavors to continue its active role in contributing to collaboration between our country and Belt and Road economies. Thanks to the one country, two systems principle, Hong Kong has the distinctive advantage of enjoying strong national support while being closely connected with the rest of the world. Proudly, apart from being a leading international financial center, Hong Kong is also a world-renowned center for international legal and dispute resolution services. We boast a large pool of talents with sophisticated and diversified experience in cross-border deal-making and handling international law matters. We also have first-class infrastructure and facilities in international dispute resolution. The International Organization for Mediation Preparatory Office will be set up in Hong Kong to prepare for the organization's establishment and provision of friendly, flexible, economical, and efficient mediation services for international disputes. Less than 3 weeks ago, our Hong Kong Legal Week brought together internationally renowned legal experts and academics from the mainland and overseas, including prominent representatives from the three sisters of private international law, the International Institute for the Unification of Private Law, the Hague Conference on Private International Law, and the United Nations Commission on International Trade Law. These are just some examples of the prowess of our legal services and international connectivity. Hong Kong is well placed to contribute to the high standard opening up of China's market and to serve as a platform for collaboration between our country and more than 180 countries and international organizations under the Belt and Road Initiative. Hong Kong will continue to capitalize on the unique advantages of one country, two systems, safeguard the rule of law under the Basic Law, and integrate actively into the development of the Belt and Road Initiative to foster cooperation in the global arena. We will make full use of the gifts that are bestowed upon us and strive to let our Pearl of the Orient shine brighter than ever. On that note, I wish you all a fruitful conference. Thank you very much.
再一次感謝行政長官為我哋今日嘅論壇係預錄致辭嘅。接下來，我們恭請中華人民共和國國務院港澳事務辦公室副主任王靈桂副主任為我們致辭。
The next recording will be from the Deputy Director of the Hong Kong and Macau's Office of the State Council of the People's Republic of China, Mr. Wang Lingui.
李家超行政长官、各位嘉宾、各位朋友，大家上午好！很高兴应香港基本法教育协会邀请，参加“一国两制”与“一带一路”国际法律论坛。2022年对国家、对香港都是极不寻常、极不平凡的一年。前不久，我们胜利召开举世瞩目的中国共产党第20次全国代表大会。习近平总书记在大会报告中提到，新时代10年“一国两制”和“一带一路”建设的骄人成绩。今年7月1日，习近平总书记亲临香港，并在出席香港回归祖国25周年庆典活动时指出，“一国两制”这样的好制度必须长期坚持。中央全力支持香港对接“一带一路”高质量发展等国家战略。习近平总书记的中央讲话对我们继续推进“一国两制”行稳致远和“一带一路”高质量发展都具有重要的指导意义。当前，香港社会各界深入学习贯彻20大报告精神，用实际行动诠释香港由治及兴的新气象，特别是近期连续举办香港金融科技周、国际金融领袖投资峰会、香港法律周等重大活动，引起国际社会热烈反响。我们熟悉的东方之珠回来了，活力光彩更胜往昔。今天我很高兴能和各位国内外专家学者齐聚一堂，一起探讨“一国两制”和“一带一路”建设中的法律问题。我想和大家分享如下观点：“一带一路”倡议是习近平总书记在2013年提出的国际合作倡议，旨在借用古代丝绸之路的历史符号，与沿线国家共同打造政治互信、经济融合、文化包容的利益共同体、命运共同体、责任共同体，是当今世界深受欢迎的国际公共产品和国际合作平台。“一带一路”倡议覆盖经贸、投资、 金融、货币和争端解决等众多领域，是超越外交、国际关系、全球治理等单一领域和范畴的综合性倡导与行动计划。作为我国发起多方参与的国际合作机制，“一带一路”倡议要求明确各方共同遵循的基本原则，针对治理议题形成稳定的法律框架和相对固定的法律治理平台，清晰界定各方权利义务和解决争端的法律路径，这些都离不开法治的基础支撑作用。习近平总书记多次强调，推动共建“一带一路”需要法治进行保障。可以说，法治化是“一带一路”高质量发展的必然要求和核心属性。法治“一带一路”的发展最终目标是构建起服务于“一带一路”建设、确保沿线各国共享建设和发展成果的一套制度体系。在推进法治“一带一路”建设的过程中，香港作为重要节点城市，作为我国唯一实行普通法的司法管辖区，具有法律服务领域的天然优势，可以发挥不可替代的重要作用。一是提供法律专业服务，香港有11000多名职业事务律师，1600多名大律师，完全能够为“一带一路”建设各方，特别是中资企业参与“一带一路”项目合作，提供优质的国际法律服务。二是提供争端解决机制，海牙国际司法会议、联合国国际贸易法委员会与特区政府合作项目、亚非法协香港区域仲裁中心、中国国际经济贸易仲裁委员会等机构都已落户香港。近日，中方与多国达成联合声明，将成立国际调解院，筹备办公室将设在香港特区。香港作为亚太区国际法律及解决争议服务中心的地位不断巩固和提升，将为“一带一路”建设提供优质的争端解决服务。三是培养涉外法治人才，推动“一带一路”建设需要大批具有国际视野、通晓国际规则、国家观念浓厚的涉外法治人才。香港特区可以通过选派爱国爱港的香港法律人才参与国际组织工作，也可以利用香港的法律教育资源优势，为内地相关部门和企业培养储备涉外法治人才，打造“一带一路”法律人才高地。此外，香港是东西方文化交流窗口，与“一带一路”沿线有关国家具有文脉相承的人文优势，可以通过形式多样、喜闻乐见的方式和扎实专业的法律服务实际，向世界讲好“一带一路”故事，讲好“一国两制”成功实践的香港故事。各位嘉宾、各位朋友，未来5年是香港开创新局面、实现新飞跃的关键期。作为共建“一带一路”的积极参与者、贡献者、受益者，香港在提供法治保障方面大有可为、大有作为。我相信，香港一定能在融入国家发展大局、参与共建“一带一路”高质量发展的过程中，实现自身更好、更大的发展。谢谢大家。
再次感谢王副主任的致辞。下面我们恭请今天亲临我们现场的中央人民政府驻香港特别行政区联络办公室陈东副主任来到台上为我们致辞，有请。
And next up, we have the Vice Director of the Liaison Office of the Central People's Government in the Hong Kong SAR, Mr. Chen Dong, to give us a speech.
尊敬的李家超行政长官、各位嘉宾、女士们、先生们，前不久顺利召开的中国共产党第20次全国代表大会上，习近平总书记为新时代新征程党和国家事业发展做出了一系列战略部署，擘画了以中国式现代化全面推进中华民族伟大复兴的宏伟蓝图。20大报告 系统阐述了新时代坚持和完善一国两制的新理念、新思想、新战略，是推动香港开启由治及兴新局面的行动指南。这一段时间，香港社会以前所未有的热情学习、宣讲、贯彻20大精神。本次论坛就是以一国两制与一带一路为主题深入研讨，具有很高的理论价值和实践意义。借此机会，我代表香港中联办对论坛的召开表示热烈的祝贺，并与大家分享3点体会：一、香港在共建“一带一路”中具有独特的地位和优势。习近平总书记7月1日在港重要讲话，充分肯定了“一国两制”实践在香港取得举世公认的成功，充分阐述了香港的独特地位和优势。25年来，香港经济蓬勃发展，国际金融、航运、贸易中心地位稳固，创新科技产业迅速兴起，自由开放悬冠全球，营商环境世界一流。香港参与并助力“一带一路”建设，展示了香港所长，凸显了香港独特的作用和价值，亦是自由贸易历史悠久、闻名于世。香港自开埠以来，就是一个开放的自由港，成为世界各国通商通航的重要枢纽和贸易的重要集散地。回归以来，香港以背靠祖国、连通世界的优势，不断强化其自由港和独立关税区的地位，持续加强与世界各地，包括“一带一路”沿线国家的经贸往来，在全球设有65个经济贸易办事处，累计与20个经济体签订了8份自贸协定，正积极地申请加入区域全面经济伙伴关系协定。香港成为全球第6大商品贸易的经济体，国际贸易中心地位持续巩固。二是作为国际金融中心的地位日益凸显。香港作为世界领先的股票集资市场、亚洲主要的私募中心、蓬勃的债券市场，为“一带一路”优质企业提供充足的资金和融资渠道。全球约75%的离岸人民币支付额经香港处理，是离岸人民币的业务枢纽，为“一带一路”市场提供了多元化的金融服务。前段时间，行政长官李家超先生、财政司长陈茂波先生吩咐东南亚、中东宣介香港，激发了“一带一路”沿线更多企业来港融资 投资的热情和意愿。三是拼船出海的企业越来越多，香港商界积极联合内地企业走出去，加大对“一带一路”沿线国家的投资。比如，香港企业家严宝林女士响应“一带一路”倡议，在孟加拉国投资办厂，带动当地基建和就业，让一个水电不通的村庄变成了繁华的市镇。香港服装企业联泰集团与内地品牌合作，进军越南、菲律宾、马来西亚等东南亚市场。在柬埔寨西哈努克港经济区，来自香港投资的项目就达19个，涉及服装、箱包、电器等行业。这些例子不胜枚举，与投资地之间实现了合作双赢。四是航运航空开辟了畅通便捷的国际通道。香港是全球第4大国际航运中心，与90多个“一带一路”沿线国家有海上贸易往来。2021年集装箱吞吐量近1800万标准箱。目前，香港有900多家公司提供船舶管理、租赁、融资和航运保险等高增值的优质服务，是亚太海事服务和仲裁中心。香港还拥有世界级的国际机场，第3条跑道已经正式启用。全球超过120家航空公司在港运营，航空货运量高居全球首位。这些独特显著的优势，将在共建“一带一路”中得到充分的发挥和持续的释放。2，用好普通话，为共建“一带一路”提供优质的法律服务和保障。习近平总书记7月1日在港重要讲话2次提到香港普通话制度，这充分体现了包括普通话在内的原有法律制度是香港自由、开放、规范营商环境的重要支撑和保障。一是普通话具有多元兼容性。“一带一路”横跨欧亚非近150个国家和地区，涵盖世界各大法系，不同法系之间法律传统、理念、规则和实践都不尽相同。普通法系是当代的主要法系之一，其特质包括在不同中寻找共同，契合共商、共建、共享的原则。香港普通话历经100多年，特别是回归25年的发展，已形成“一国两制”下具有香港特色的普通话制度体系，可为不同的法系之间的融合、平衡和争议解决提供路径和支持。2是普通话具有广泛的实用性。当前世界1/3，约24亿人口生活在普通话实用地区。“一带一路”沿线国家也有20多个国家实行普通话制度。香港作为中国唯一实用普通话的城市，可以借助“一国两制”优势， 助力国内企业与“一带一路”不同法域的市场主体合作，实现无缝对接。三是普通话具有普遍的认受性。香港法治指数长期排名全球前列，香港特别行政区法院的判例符合现代国际经贸通行的规则，仲裁裁决获得了143个国家和地区的承认和知情。香港国际仲裁中心2021年受理514起案件，大多是国际和涉外的案件，争议金额达546亿港元，居世界前列。日前，国家将国际调解院筹备办公室设在香港，将进一步提升香港亚太区国际法律及解决争议中心的地位。四是普通话具有市场的适应性。普通话具有稳定市场预期和灵活应对市场变化的特点，有助于“一带一路”国家金融市场发展、基础设施建设、海外投资并购、中小企业创新发展。共建“一带一路”主体多、范围广，商业活动活跃且复杂。香港具有提供国际法律及争议解决服务的能力。全球100大律所半数以上均在香港设有分所，世界主要仲裁机构均在港设有代表处。香港有近15000名本地的法律执业者，1500名来自33个司法管辖区的海外注册律师，以及1000余名国际仲裁专才，2100多名调解员。这些宝贵的法律资源将为高质量共建“一带一路”提供优质的法律服务和强大的人才支撑。三，香港能在共建“一带一路”高质量发展中发挥更大作用。习近平总书记强调，中央全力支持香港抓住国家发展带来的历史机遇，主动对接“十四五”规划、粤港澳大湾区建设和“一带一路”高质量发展等国家战略。韩正副总理在香港第7届“一带一路”高峰论坛上提出的4点希望，这些都为香港参与共建“一带一路”指明了方向。新征程、新阶段，相信香港一定能够抢抓机遇，在“一带一路”高质量发展中有更大的担当、更大的作为、更大的建树。一是树立开放包容的理念。香港一直被公认为全球最自由开放、最具竞争力的经济体。开放包容既是中华优秀文化的重要基因，也是香港地域文化的一大特质。香港作为国际化的港口大都市，处处展现出多元文化的魅力。在香港街头，总能看到来自世界各地的人们，听到多国的语言，品尝到东西方的美食。一国两制让东方之珠尽显东西合璧、开放包容的风采。香港应率先践行和平合作、开放包容、互学互鉴、 互利共赢的丝路精神，以海纳百川的宽阔胸襟，投入到共建“一带一路”高质量的发展时代洪流。二是着力加强法律专业服务。国家“十四五”规划明确支持香港建设亚太区国际法律及解决争议服务中心。香港应深化与内地民商事司法及争议解决等相关工作，加强与国际和区域之间的法律合作，推动香港在大湾区“一带一路”沿线国家的交易和争议解决服务，抓住国际调解院筹备办公室在港落地的重大机遇，创造更加优越条件，为各类国际争端提供友好、灵活、经济、便捷的解决方案。三是强化知识产权保护。强大的知识产权保护体系是创新发展的重要保障，在“一带一路”沿线国家经济增长中发挥日益重要的作用。做好知识产权保护，不仅创造了更多的商机和交易模式，也给香港发展带来了新的机遇。“十四五”规划支持香港成为区域知识产权贸易中心，香港应进一步健全和完善知识产权的保护制度，特别是加强在数字经济发展中的产权保护，为“一带一路”沿线国家提供创新动力。四是架设民心相通的桥梁。香港中西文化荟萃，多元文化交融，在“一带一路”沿线国家有巨大的影响力和深厚的人脉。香港应用好用足国家支持发展中外文化艺术交流中心的政策，扩大与“一带一路”沿线国家文化教育合作，进一步促进人文交流、民心相通，推动人类命运共同体理念落地生根。女士们、先生们，“一带一路”是一条凝聚人心、汇聚力量之路。站在由治及兴的新起点上，只要香港社会各界坚持团结奋斗、勇毅前行，就一定能够更好地参与共建“一带一路”高质量发展，更好地融入国家发展大局，在全面建设社会主义现代化国家、全面推进中华民族伟大复兴的新征程上做出更大的贡献。谢谢大家。
再次感谢陈栋副主任的致辞，请回座。下面我们继续恭请中华人民共和国外交部驻香港特别行政区特派员公署放坚民副特派员移步台上为我们致辞，有请。
May we now invite the Deputy Commissioner of the Office of the Commissioner of the Ministry of Foreign Affairs of the People's Republic of China in the Hong Kong Special Administration, Mr. Fang Jianmin.
尊敬的李家超行政长官、王灵桂副主任、陈东副主任、梁美芬博士、各位嘉宾、女士们、先生们，时序长意，华章热心。即将过去的2020年是具有里程碑意义的一年，我们隆重庆祝香港回归祖国25周年。习近平主席亲临香港，并发表重要的讲话，“一国两制”香港实践开启崭新篇章。中国共产党第20次 全国代表大会顺利召开，科学擘画全面建设社会主义现代化国家的宏伟蓝图，党和国家事业发展踏上了新征程。今年也是共建“一带一路”走过的第9个年头，9载耕耘，春花秋实，“一带一路”由理念变为行动，由愿景化为现实，成为深受欢迎的国际公共产品和构建人类命运共同体的重要实践平台。20大报告明确指出，中国将继续推进高水平对外开放，推动共建“一带一路”高质量发展。这是中国坚持对外开放不动摇的郑重宣示，也是中国以自身发展更好造福世界的庄严承诺。第一，共建“一带一路”拓展了全球治理新实践。共建“一带一路”因应全球治理赤字不断加重的现实挑战，有效对接各国政策和发展战略，促进协调联动发展，为丰富完善全球治理提供新实践、新理念、新动力。面向未来，“一带一路”将继续着眼全球治理体系变革的内在要求，本着和平合作、开放包容、互学互鉴、互利共赢的丝路精神推进合作，不断标注国际合作新高度，引领全球治理新航向。第二，共建“一带一路”分享中国发展新机遇，“一带一路”连通中国发展和世界机遇，欢迎各方搭乘中国发展的快车、便车。到2030年，共建“一带一路”有望使相关国家760万人摆脱极端贫困，3200万人摆脱中等贫困。面向未来，中国将加快构建新发展格局，着力推动高质量发展，为共建“一带一路”提供更多机遇、更大空间、更优路径，推动共建国家经济大融合、发展大联动、成果大共享。第三，共建“一带一路”助力香港续写新篇章。9年来，香港积极与共建国家商签合作协议，开展贸易投资合作、服务标准联通、国际金融合作和人文交流，为“一带一路”建设提供了高质量的法律、航运、金融服务，有力拓展了自身发展空间。面向未来，香港必将充分把握健康、绿色、数字、创新等共建“一带一路”新领域和增长点，在“一带一路”建设中继续发挥独特重要作用，实现自身更快、更好发展。女士们、先生们，法治是“一国两制”香港实践风雨不改、历久弥新的鲜明标识，也是共建“一带一路”不可或缺的重要基础和保障。在此，我愿同关心支持“一国两制”事宜和“一带一路”建设的特区及全球法律专业人士分享3点建议：一是切实发挥香港法治优势。香港回归后，特区法律规则融通中外，法律专业人才济济，法律服务享誉国际的优势不断彰显。法律专业服务是香港所长和高质量共建“一带一路”所需的重要交汇点。希望各位法律界同仁发挥专长优势，做强法律服务， 促进跨境规则融通，为“一带一路”国际合作提供更加便捷、高效的法律服务，不断擦亮香港参与共建“一带一路”的金字招牌。二是共同讲好香港法治故事。香港回归后，特区法治指数大幅跃升，法治排名稳居世界前列，成为全球最欢迎的仲裁地之一。但近年来，个别西方国家肆意造谣抹黑特区法治状况，贬损特区法治形象。希望各位法律界同仁用好“一带一路”沟通对话平台，密切法治交流，促进民心相通，理直气壮讲好香港法治故事，讲好“一国两制”成功实践故事，坚决捍卫特区法治形象。三是关心支持国际调解院建设。国际调解院筹备办公室即将在香港设立，这体现了国家对香港便利营商环境、成熟法律体系、专业法律服务的认可，也将有力提升香港亚太区国际法律和争议解决服务中心地位。希望大家为国际调解院建设贡献专业智慧，推动香港发挥在国际调解领域的独特优势，在“一带一路”预防纠纷与解决中发挥更大的作用。女士们、先生们，在香港新起点和国家新征程上，外交部驻港公署将继续发挥外交所长，和大家一道携手助力香港在参与“一带一路”建设中充分彰显“一国两制”特色和优势，共同支持香港在融入国家发展和民族复兴的伟大进程中创造美好未来。最后，预祝本次论坛取得圆满成功，谢谢大家。
再次感謝方建明副特派員親臨我們現場為我們致辭，感謝。好啦，我哋今日嘅論壇呢，亦都即將開始啦，亦都再一次提提大家，如果大家呢係需要即時傳譯嘅耳機呢，可以舉一舉手，咁我哋嘅工作人員呢，可以呢將即時傳譯嘅耳機呢係送嚟你嘅座位附近嘅。
In case there's anyone here needs simultaneous interpretation, just raise your hand and one of our staff members will hand you one of the headsets.
假如在场我有任何的朋友，你们需要同传耳机的话，现在可以举手，我们的工作人員會把耳機可以帶給你們。咁大家咧，如果攞到呢個嘅即時傳譯耳機之後咧，第一台係英語嘅傳譯，第二台係普通話，第三台係廣東話嘅。
For those with a headset, Channel 1 will be English, Channel 2 will be Mandarin, and Channel 3 will be Cantonese.
就大家已經拿到同傳耳機的話，第一台為英語，第二台為普通話，而第三台為廣東話。
Sia，而家製作公司轉場期間呢，不如我哋大約介紹下今日主辦單位嘅一啲背景，俾大家再出席嘅各位知道一下我哋呢個機構係做乜嘢嘅。
好啊，冇問題啊。咁大家都知道啦，其實基本法咧轉眼間咧已經頒布咗有32年嘅時間啦。喺回歸近25年嘅過程入邊啦，內地同埋香港就香港基本法嘅問題咧，其實都發生過唔少嘅爭拗。咁其中咧牽涉到普通法同埋中國法對基本法同埋港區國安法不同嘅解釋，亦都牽涉咧香港自回歸以嚟喺教育上呢係缺乏對一國兩制同埋基本法嘅系統認識所致嘅。咁又見及此，我哋一班長期從事教育啦，同埋擁護中華人民共和國憲法同埋中華人民共和國香港特別行政區基本法，並且以研究香港法律、中國法律嘅學者呢，喺2004年就決定組成香港基本法教育協會，咁有系統咁樣向我哋香港各界，包括大學啦、中學同埋小學嘅老師、政府公務員、 立法、司法、傳媒同埋普羅市民呢，有系統咁樣教育基本法同埋一國兩制嘅體系同埋基本嘅理論嘅。咁呢個呢，就係我哋今次論壇嘅主辦單位香港基本法教育協會咧嘅由來。咁如果大家咧想知道更加多有關我哋呢個協會嘅資訊啦，同埋咧如果大家咧都想知道我哋今日整個嘅流程同埋各個講者嘅資料嘅話咧，其實大家凳上面咧都有一個 folder 裏邊咧都有齊晒我哋協會嘅簡介啦，同埋今日嘅流程同埋各個講者嘅一啲介紹嘅。好啦，咁我見咧工作人員都準備得差唔多咯喎，咁不如我哋都介紹下我哋第一個環節啦。
嚟緊我哋會進行第一節嘅演講，第一節嘅主題係關於香港回歸祖國25週年一國兩制法治嘅建設。The theme of the first session would be One Country, Two Systems and the Infrastructure of the Rule of Law。跟住落嚟咧，我哋請我哋呢節嘅主持人梁美芬博士再一次上台，同埋我哋邀請下今次嘅演講嘉賓一齊上台啊！
好啦，我哋都有請我哋3位嘅主講嘉賓，全國人大常委會香港特別行政區基本法委員會副主任委員譚惠珠 GBM GBS-JP。
The Honourable Maria Tam Wai Ju, GBM GPS-JP, Deputy Director of the Hong Kong SAR Basic Law Committee of the MPCSC。
前香港特別行政區律政司司長梁愛詩 GBM-JP。
The former Secretary of Justice of the Hong Kong SAR, the Honourable LC Leung Oi Si, GBM-JP。 以及前香港特別行政區立法會主席范徐麗泰 GBM GBS-JP。 And finally, the former President of Electrical of the Hong Kong SAR, the Honourable Rita Fan Shu Lai Tai。 請大家再一次以熱烈嘅掌聲歡迎我哋台上咁多位嘉賓。咁我哋都將時間咧交俾呢一節嘅主持梁博士。
好多謝咁多位嘉賓，我呢就更加榮幸咧可以主持呢一節嘅會議。大家睇到咧呢一節嗰個設計呢係非常之難得，係佢哋3位咧可以同場啊！佢哋係對於香港回歸咧有顯赫貢獻嘅人士，即係我哋咧即係廣東話有一句咧就係做緊僆嘅時候咧，就係聽緊佢哋咧就係好勤力去起草基本法。咁啊，第一位我要介紹嘅係譚惠珠副主任呢，佢係直情係喺起草基本法嘅5年係有參與，應該呢當時有好多係談判要考慮香港嘅問題都有經歷過。而梁愛詩女士大家亦都係好熟悉，佢係講喺回歸之前，我哋已經係成日睇電視睇到佢呢，就係講即係內地香港法制一路去到佢去到特區政府同埋基本法嘅重要角色呢。我就好希望呢，就係大家透過呢一個嘅環節，將回歸祖國前後嗰個香港係一國兩制嘅落實，係可以咧將呢個故事有機會就講得好清楚。仲有范太呢，就係我哋首屆嘅立法會主席，亦都係回歸祖國之前行政立法會嘅成員，係好清楚我哋成個香港行政立法司法個體制。咁時間呢就係好寶貴，所以我首先即刻將時間呢就交俾我哋譚惠珠女士。我就特別邀請佢講廣東話嘅，因為香港呢係兩文三語，所以我發俾你哋嘅邀請函有啲係中文，有啲係英文，就係已經係分咗類，因為我哋係應該，我哋就係兩文三語，所以呢我特別邀請譚惠珠女士係用廣東話發言嘅。請譚主任。
好多謝美芬博士。好，大家都聽到。陳東副主任，多謝你今日蒞臨同埋剛才一個好啟發性嘅講話。各位朋友，我好榮幸喺台上呢，我諗可能係有關基本法裏邊比較強嘅4位女士，我哋可以同台咧都唔容易。我負責嘅咧就係講我哋寫基本法嘅時候咧係有啲乜嘢嘅考量，同埋咧最後對於本來白紙一張嘅工作去到寫到160條咧，中間比較上有爭議性辣手嘅問題咧係點樣解決？咁就首先講一國兩制嘅誕生，就其實咧 由1840年鴉片戰爭到1984年10月19號中英聯合聲明談判呢段歷史咧，大家好熟悉。基本法嘅序言咧就寫咗國家咧係按照憲法第31條設立香港特別行政區，按一國兩制嘅方針，唔喺香港實行社會主義嘅制度同埋政策，保持原有嘅資本主義制度。並且咧由全國人大制定香港基本法，就規定咗香港實行嘅制度咧，嚟到保障國家對香港嘅基本方針政策嘅實施。咁設立特別行政區咧係一個國家主權嘅行為。按住憲法第57條咧，中華人民共和國全國人民代表大會係最高嘅權力機關，佢嘅常設機關咧就係常委會。咁根據憲法嘅第64條第14項，同埋全國人民代表大會咧可以決定特別行政區嘅設立同埋佢嘅制度。62條嘅第16項咧就話，給予全國人大應當由最高國家權力機關行使嘅其他職權。咁因此咧，我哋知道憲法咧對香港咧係絕對係有效嘅。喺1990年4月10號咧，全國人大就按一國兩制嘅方針通過咗基本法，授權呢兩個字好緊要啊，同埋規定嘅香港特別行政區咧係實行高度自治、港人治港。香港係冇剩餘權力，並且咧由全國人大監督基本法嘅實施，即係往後喺香港解決一連串嘅問題啦，都係由於人大有呢個監督權。憲法同埋基本法就構成香港特別行政區嘅一個憲制架構。其實我講呢嘢大家都知㗎啦，每一粒珠你都掂過、講過、研究過。我只係揾一條線咧，去將佢串起上嚟，等大家知道當時我哋嘅考量。咁第二樣我要講嘅咧，就係鄧小平先生咧係講一國兩制嘅語錄。好我個發言嘅內容。嗰個大綱嘅 PPT 咧，如果可以嘅啦，你麻煩打出嚟，等大家知道咧，我唔會講得太長。鄧小平先生咧係曾經喺1984即1987年咧係討論有關一國兩制嘅內容嘅精神嘅主導思想。第一，佢話愛國者治港，佢話港人治港咧有個界線同埋標準，就必須由愛國者為主體嘅香港人。港人治港，愛國者嘅標準呢，就係尊重自己嘅民族，誠心誠意擁護祖國，恢復對香港行使主權，唔損害香港嘅繁榮同埋穩定。咁香港嘅政治制度呢，佢就話，亦唔可以咧係完全西化，亦唔可以咧係照搬西方嘅一套，因為香港根本就唔係實行美國或者英國嘅制度。咁佢話，如果係完全照搬咗，譬如講三權分立，一陣間我要回頭講呢一點，搞英美嘅議會制度嚟到判斷呢樣係是否民主嘅話咧，我認為唔適宜嘅。我哋咧要切合實際，根據自己嘅特點嚟決定自己嘅制度。咁至於話50年不變啦，當然我哋知道習近平主席今年7·1咧已經將呢個謎咧係解咗俾我哋聽。但係當年咧，鄧小平先生咧講50年不變咧，佢話唔會係一成不變嘅，但係你要變得更好。佢話如果有啲咩變，一定要變得更好，更有利於香港嘅繁榮同埋發展，同埋唔損害香港人嘅利益。呢種變咧就值得大家歡迎嘅。我哋總唔能夠講香港資本主義制度下所有嘅方式都係完美無缺噃，要變。如果你拒絕嘅話，你就唔能夠進步啦。所以資本主義咧係可以，同埋亦都一定要變得更好。至於國家安全咧，佢又話咗啦，佢話唔能夠籠統咁擔心干預，有啲干預係必要嘅。你睇下呢個干預係有損香港人嘅利益，有利於香港嘅繁榮同埋穩定，抑或損害香港人嘅利益，損害香港人嘅繁榮同埋穩定。你設以為冇破壞力量。如果發生動亂，中央就要干預，由亂變治。1984年佢用咗呢4個字，由亂變治。這些干預應該是歡迎還是拒絕呢？應該歡迎。咁佢亦都講，即係如果香港有行動 要將香港變成一個喺民主嘅幌子下反對大陸嘅基地，怎麼辦？那就非干預不可。干預首先就係香港行政機構要干預。咁跟住我哋要做一個當時係真係白紙一張要構思嘅，就係我哋嘅行政機關，我哋嘅行政體系啦，就係香港政制同埋憲制嘅架構。咁第一個拿手問題咧，就基本法同埋咧係憲法嘅關係。本來大家都明白，每一個國家嘅憲法咧必然係全國適用嘅，但係我哋當時起草咧係有人提出嘅意見，佢話既然有基本法啦，你就唔需要憲法啦。基本法係小憲法，代替咗憲法，因為憲法裏邊有好多章節咧係根本唔適宜係資本制度裏邊一個社會嘅運作，或者咧係執行。咁內地嘅委員咧就好清楚呢個論點係錯嘅。咁我哋都知，但係為咗要解決呢個問題嘅話咧，即係喺基本法嘅條文裏面可以表達到憲法同埋基本法嘅關係咧。我哋有個小組將憲法咧係油咗不同嘅顏色，咁但係咧就放棄啦，因為根本咧係前文後語唔能夠拆開。咁最後嘅結論係點咧？最後嘅結論咧就有人提出咗。我哋其實喺基本法裏邊咧係寫一個條文就係基本法嘅第11條，就話喺香港特別行政區裏邊咧係有關我哋嘅行政立法政治社會經濟制度，就以本法為依歸。即係你要睇呢啲制度咧，你睇第11條，但係唔可以抵觸憲法第31條。咁由於我哋冇剩餘權力，我哋可以做嘅嘢已經寫咗喺基本法第11條。咁以外嘅事，如果需要有權力解決咧，咁就必定係國家使用佢憲法上嘅權力啦。咁例如我哋喺深圳西口岸嗰度做咗一個一地兩檢，就喺深圳嘅地域之內。咁但係係香港嘅司法管轄權。咁於是咧，我哋了解到有一啲權力咧，香港係需要嘅，但係我哋冇寫基本法嘅。我哋點樣解決咧？我哋寫基本法第20條，就話中央政府咧係可以另外授權等香港咧係可以有呢啲權力去解決其他問題，所以有一個額外授權嘅條文，令到我哋深圳西口岸咧係可以咧係變成現實。咁我哋就係用呢個方法，就係解決基本法同埋咧係憲法嘅關係。就係你先睇第11條，11條以外嘅嘢咧，你就由憲法嗰度處理啦。因為大家都好清楚啦，我哋過去2年嘅經驗咧，都話俾我哋聽咧，憲法有幾條咧，就係為咗香港咧就解決好多問題嘅。譬如第57條就話常委會咧就係人大嘅常設機關。譬如話62條第14款咧就話人大可以設定香港特別行政區嘅制度，同埋咧我哋基本法嘅解釋權係屬於常委會，咁亦都咧修改權咧就全國人大。咁我下一度咧就將呢個子法與母法，即係憲法同基本法嗰個問題咧，就用第11條同埋第20條解決之外咧，咁我就開始講中央地方關係嘅話，大家睇個圖咯喎。咁咧係用呢個圖嘅話咧，唔該 PPT 第2章有一個圖。咁呢個圖咧就睇到咧，我哋全國人大就係我哋嘅最高權力機關咁咧就下邊就人大常委會你頭一個大 box 裏邊嗰個常委會咧係錯嘅，全國人大大會。咁佢咧就係根據頭先第57條咧，就係常設機關咧，人大常委會。咁人大咧就監督國務院嘅工作啦，裏邊有喺北京嘅有港澳辦啦，喺香港嘅有中聯辦啦，就係中央同埋地方嘅一個聯繫啦。因為咧我哋係直屬於我哋直轄於中央人民政府，咁授權咧係俾我哋高度自治嘅噃。咁我哋睇到咧呢個直轄 中央人民政府咧就係基本法第12條啦。咁然之後咧，下邊咧你哋睇到特別行政區長官咧係凸顯咗出嚟嘅，佢唔係同我哋嘅立法或者司法咧係平排嘅。原因係乜嘢咧？因為整個基本法裏邊咧，只係得43條裏邊話，我哋行政長官咧係負責執行基本法，向中央同埋咧係地區負責。咁所以咧，如果中央要同特區發生關係嘅話咧，佢經嘅就係行政長官，不是其他人。咁所以咧，有一個講法咧，就係我哋行政長官負責制。咁人大同我哋嘅立法會又有啲咩關係咧？其實係有嘅，因為我頭先講咧就係有個授權啊嘛。既然係中央授權嘅話咧，佢又可以領導你，可以監督你啦。我哋係處於一個被領導、被監督嘅關係。喺立法會方面咧，當然啦，基本法第2條咧就俾咗我哋嘅立法權。咁但係第17條咧就話香港嘅法律咧喺我哋立法會通過、行政長官簽署之後，都要咧係攞上去常委會備案。咁如果呢條法律咧係有關中央地方關係或者中央事權嘅話，而係可能抵觸基本法咧，咁就常委會咧係徵詢過基本法委員會嘅意見，當然常委會作決定啦。如果認為佢都抵觸咗咧，佢就將呢條法律咧就發回重議，佢就唔幫你修改。如果佢幫你修改嘅話咧，佢就喺後門幫你立法啦。立法權俾咗你，佢唔幫你修改，送翻嚟香港，咁啊由佢話係抵觸嗰一刻開始咧，咁個法律就失效嚇，但係冇逆及力。咁香港自己就決定咧係點樣補償受損害嘅人，或者糾正個情況。咁呢一個咧就係常委會同我哋立法機關嗰種授權與監督嘅關係啦。咁你個圖嘅右邊咧，你會睇到咧係原來常委會同我哋司法機構都好有關係。咁呢點大家明啦嚇，因為我哋經過5次釋法啊嘛。咁第158條咧就係講基本法嘅解釋權。咁人大常委會又點樣監督基本法喺司法方面嘅執行咧？咁當然啦，我哋係司法獨立我哋唔係由常委會代替我哋審一件案或者判決一件案嘅。咁但係咧有一個問題要解決嘅咧，就係我哋香港傳統上咧就係英國嘅普通法嘅制度，我哋係用司法解釋權。立法會立咗法咧，佢解釋法律冇人理佢嘅，係要靠咧喺法庭裏邊有一個判決，咁先至真係有效可以執行。咁最終嘅解釋權，我哋嘅有終審庭啦，咁係一定應該喺終審庭啦。咁但係基本法咧就唔同啦。解釋香港本身嘅法律咧，你當然嚟睇終審庭。但你如果係解釋基本法咧，咪有個特別嘅安排噃。點解要需要一個特別嘅安排咧？因為我哋嘅憲法裏邊咧，老早將解釋一條全國性法律嘅權咧，係俾咗常委會，係大陸法系嘅法統咧，我哋係用立法解釋權嚇，最終嘅解釋權咧就喺常委會嗰度。憲法我哋唔會改嚇，咁因此第158條第1款咧就話基本法嘅解釋權咧就喺常委會。但係我哋個法庭咧係被授權咧係可以解釋全部基本法，都包括高度自治範圍啊，同埋咧係中央地方關係或者中央事權嘅問題。但係如果係後兩者，即係中央地方關係、中央事權嘅問題嘅條文咧，喺審案嘅時候咧係對件案有影響咧，咁我哋嘅終審庭咧喺總之係作出最終判決之前，咁啊應該係終審庭啦。就將佢咧係呈上去人大常委會嗰度咧，係要求釋法。咁然之後，如果係釋法咧，就跟住呢一個釋法咧去判決嗰個條文嘅意思啦。咁如果佢影響件案，咁係另一回事啦。因為常委會咧就唔會係諗邊個贏邊個輸嘅，佢最緊要咧就係呢條法律點樣解釋。咁我哋寫基本法嘅時候咧，遇見一個大問題啦。一方面係普通法嘅司法解釋權，我哋有終審庭；另一方面咧立法解釋權，我哋已經有憲法。 咁樣我哋就110火嘅電力同220火嘅電力嘅相遇啦。我哋擔心爆炸，於是我哋咧係要揾一個變壓器啦。咁結果個變壓器喺邊度揾到咧？就係歐盟寫基本法咧，係1985年至1990年，當時英國仍然喺歐盟啦。咁當每一個成員國參加歐盟嘅時候咧，就要簽羅馬條約。咁羅馬條約嘅解釋又點樣做咧？就無論你喺英國嘅最終局判決之前，或者意大利係嘛羅馬法嘅鼻祖嘅終局解釋之前咧，你咧就將呢個條文咧係呈上喺盧森堡嘅歐洲法庭、歐盟嘅法庭嗰度作出一個解釋嘅話咧，就全個歐盟裏邊每一個成員都跟呢個解釋咧嚟到判有關呢個條文嘅意思啦。咁樣咧就令到所有歐盟嘅法律，包括羅馬條約啦，就可以一致啦。咁佢咧就解決咗兩個問題。第一個問題咧就將個審判權同個解釋權分開，但係咧就唔影響每一個國家自己嘅終審權。第二點咧，佢只係解釋個條文，唔係判嗰件案係誰贏誰輸。咁樣情況之下咧，就解決咗有關審判獨立嘅問題。咁我哋係用呢個方法咧，就寫咗基本法第158條嘅第1同埋第2款，就係如果係中央地方關係嘅中央事權嘅條文，喺我哋終審之前咧，就係呈常委會攞嘅解釋。如果常委會做嘅解釋咧，我哋就跟啦。咁呢樣咧就係保持咗乜嘢咧？保持咗基本法作為一個全國性嘅法律咧，喺全國嘅解釋咧都係一致。咁頭先咧講到話搞三權分立嘅問題，鄧小平先生就話我哋唔搞三權分立。咁其實三權分立咧喺我哋嘅法庭裏邊咧係經常實施同埋運用一個普通法嘅原則亦都係喺香港大家都接受咗嘅。但係佢咧就多數係一個審案嘅時候咧，當法庭咧係要決定我審呢件案裏邊其中被起訴嘅人佢究竟係咪屬於佢嘅權利咧？如果佢係立法方面嘅行為或者行政方面嘅行為，因為咧對法庭而言咧喺憲制上咧係三權，就係司法、行政、立法三權啦，係分開各司其職嘅。咁Elsie 咧有個好好嘅方法嚟到講呢個安排咧。佢曾經話呢個係三權分治。咁李飛主任咧亦都講過，你唔可以淨係諗三權你仲有主權要諗噃。咁我哋咧就要分開咧，就係喺審案裏邊法庭用嘅 separation of powers 咧，佢大部分時候咧都係講 judicial deference， 係講司法謙抑。佢大部分時候咧都唔係話我哋嘅憲制架構咧係三權分立，因為第43條咧已經突顯咗我哋行政長官嘅地位，同埋咧我哋點樣咧同中央發生關係。我哋嘅憲制架構咧仍然係憲法同埋基本法所構成嘅。三權分立咧係我哋喺香港內部係需要解決一啲行政或者立法上嘅行為是否恰當，咁樣情況之下咧運用嘅係最多。咁呢個咧大致上咧就係中央地方關係嘅運作。咁另一方面咧，我哋下邊要講嘅咧就係香港嘅政治體制。仲有幾多分鐘？要快啲啦！OK， 好。香港嘅政治體制咧就係行政主導。呢度冇寫喺基本法亦都冇寫行政主導4個字，因為 OK， 因為咧就已經因為當時咧好多爭議，咁但係咧我幾個例子咧係證明咗香港行政主導第一咧就係喺我哋議會裏邊嘅議程咧，首先咧就所有政府嘅提案咧都要優先處理。第二咧就係政府嘅提案或者法案咧係 simple majority， 簡單多數就通過㗎啦。但係議員嘅提案咧係有限制嘅。第一咧就佢唔可以提有關財政方面嘅問題。 第二咧，唔可以提咧政府架構同埋政府體系運作嘅問題。第三咧，就如果佢提嘅有關政策嘅問題咧，係需要行政長官嘅書面同意，咁先就可以提出嚟。咁呢兩個方法咧，就將嗰個提案權咧就已經咧係控制咗。咁另一方面咧，真真正正到咗投票嘅時候咧，就議員嘅提案咧就需要用分組計票。而頭先講咗，政府方面咧用 simple majority， 咁呢個咧就係行政主導裏邊咧即係最關鍵性當時寫出嚟嘅幾個條文。咁就好快嚇講到行政體系啦。我諗我講到香港國安法同埋完善制度咧就完啦。好大家都知道本來咧係基本法23條咧就我哋香港自己應該自行立法。係禁止叛國等等嘅七宗罪嘅問題，咁但係由於我哋咧係冇成功做呢件事，去盡咗我哋嘅責任，盡到我哋嘅責任咧，咁因此咧就逢係有關國安嘅機制或者法律咧，都係中央政府負責嘅，呢個係佢嘅權同埋責任。咁因此咧喺2020年5月嘅時候咧，就係用全國人大決定加上常委會立法嘅方法咧，就定咗國安法，真係為我哋止暴制亂啦。正如鄧小平先生所講啦。咁另一方面咧，愛國者治港呢5個字咧，亦冇寫喺基本法，係靠宣誓嗰個條例第104條咧嚟到寫到我哋嘅公職人員知道自己要擁護中華人民共和國香港特別行政區同埋基本法，效忠同埋擁護咁因此咧，就要有一個真真正正咧，係要將呢個原則好重要嘅原則咧，係將佢制度化同埋咧係法律化。咁於是咧就係常委會嗰度咧係經過人大嘅決定咧，亦都可以為我哋香港咧係完善我哋嘅選舉制度。咁時間所限，咁簡單啲同大家講我哋當時係白紙一張寫基本法，喺個過程裏邊咧係有一啲嘅事項咧，可能而家大家都未必知道。咁我喺呢度咧係奉美分之命咧，係將其中一啲嘅細節咧係同大家解釋一下。多謝大家。對唔住啊！
多謝譚主任嚇。咁咧就我哋跟住嘅時間咧就係交俾梁愛詩女士。我哋前律政司司長請。
尊敬的陳東副主任 ，Dr. the Honorable Priscilla Leung, Ms. Maria Tam, Ms. Rita Fan, distinguished guests, ladies and gentlemen, I'm asked to address the conference on the topic of the rule of law under one country, two systems in English. But I shall be glad to join the discussion in Cantonese or Putonghua. What is the rule of law? The rule of law has a number of meanings and corollaries. As Lord Tom Bingham put it, it is difficult to define, but is constantly on people's lips. In brief, it means that everything must be done in accordance with the law. It's the principle of legality. It means that nobody is above the law. In the context of the government, its powers must derive from the law and be exercised in accordance with the law. Therefore, even the government is vested with certain discretion, the discretionary powers. The discretion must be exercised rationally and without procedural impropriety. The courts are in a position to prevent abuse. Citizens have the right to challenge in court the legality of acts of the government, including the validity of the law under which it acts. And disputes are to be adjudicated by an independent judiciary. Justice must be reasonably speedy and affordable, because if access to the courts is slow and costly, the rule of law will be impaired. The legal procedure should be transparent and the result of proceedings reasonably predictable. The law should be even-handed between the government and citizens, striking a balance between the needs of effective administration and the protection of human rights of individuals. These are people's expectation of the rule of law. These principles are fully understood in Hong Kong, not only by the Department of Justice, but by the administration in general. They form the ground rules by which government policies and legislation are formulated, and administrative decisions are made. Moreover, many court decisions involving the government since reunification indicate not only that the government continues to abide by the law and promote the rule of law, but members of the community also well understand that government is subject to the law. Before the reunification, there were pessimistic prophecies that Hong Kong would lose its value after 1997, and one of it would be the deterioration of the rule of law. I shall try to illustrate that this would not happen, and factually, it has not happened. How is the rule of law protected constitutionally? Constitutionally, the Hong Kong Basic Law has provided a solid foundation for the rule of law in Hong Kong. I'll describe a few points. Laws previously enforced, including the common law, equity, and existing ordinances and legislation, customary law, etc., continue to apply in Hong Kong, except those that contravene the Basic Law, and are subject to subsequent changes in the law. That is Article 8 of the Basic Law. Every Hong Kong resident is equal before the law, is Article 25. In the exercise of formulation of policies and drafting laws and regulations, the Department of Justice must verify whether the proposed policy, law, or regulation contravenes the Basic Law or the human rights provisions of the Basic Law. That is Article 39. Any law passed by the legislature must not contravene the Basic Law. That's Article 11. The government is accountable to an elected legislature. That is Articles 64 and 68. Courts are to adjudicate upon cases without any interference, Article 85, and judges are appointed by the chief executive on the recommendation of an independent commission. That is Article 88. Whilst the chief executive can refuse to appoint the nominated candidate, he cannot nominate his own candidate. Judges enjoy the security of tenure of office and can only be dismissed and only be removed due to their inability to perform the duties or misbehave. Even in such case, it must be investigated and found to be so by a tribunal of 3 judges before they can be dismissed. That is Article 89. Hong Kong residents have the right to bring legal proceedings before the court against the acts of the executive authorities or its personnel. Article 35. Both English and Chinese are official languages for use in courts, and in the adjudication of cases, the courts may take into account precedents from other common law jurisdictions, thereby keeping up with the development in the other common law world. Article 84. Department of Justice shall control public prosecutions without any interference, not even from the chief executive. That is Article 63. All these ensure that legality of laws, equality before the law, and judicial and prosecutorial independence are maintained and protected by our constitutional order. Whilst individuals may have failings and people may change, the system entrenched in the Basic Law is not to be changed lightly, and the rule of law is maintained. How is constitutional order implemented? Our constitutional order must be implemented through laws and in the administration of justice. During the past 25 years, there has been a host of precedents that have given life to the constitutional provisions mentioned above. Apart from the 5 interpretation of the Basic Law by the Standing Committee of the National People's Congress, which clarified and supplemented the Basic Law, common law, being part of our legal system, has also given effect to our constitutional order. In the book, the Basic Law selected drafting materials and significant cases, compiled and published by the Department of Justice in June 2022. No less than 199 cases relating to the Basic Law were included, showing that the common law has not only survived the reunification, but has also played an important role in the construction of our new legal system. Therefore, the Basic Law protection of the rule of law is not just lip services, but is actually given effect to. In his important speech delivered in the inauguration of the 6th-term government of the Hong Kong SAR on the 1st of July this year, President Xi Jinping twice mentioned the use of the common law by saying that Hong Kong, and I quote, has maintained a world-class business environment. Its previous laws, including the practice of common law, have been maintained and developed, unquote. And that, I quote, the central government fully supports Hong Kong in its efforts to maintain its distinctive status and edges, etc., and to maintain the common law so as to expand the facilities, its exchanges, and facilitate its exchanges with the world, unquote. Some people view with suspicion the propriety of including the common law as part of our legal system, since it is a product of colonial era. However, the common law since the handover has involved adapting to our new constitutional order. It does not change the Basic Law, but rather changes itself to become part of our new constitutional order. I'm glad that Chen Dong Fujiren has, in his speech, made a very succinct and thorough description of the common law. In fact, this is a subject I would like to develop. However, I'm constrained by the title assigned to me. Of course, with a good legal system, you still need independent and high-quality judges, prosecutors, barristers and solicitors, and the supporting services. The number of barristers and solicitors, as Director Chen Dong mentioned, has increased substantially since the handover, and access to justice is made easier with several free legal services like legal aid, duty lawyer scheme, legal advisory service scheme, etc. In recent years, the government has proactively promoted arbitration, mediation, and other forms of alternative dispute resolution. However, citizens must be aware of their own rights and are ready to stand up or defend themselves for the purpose of maintaining the rule of law, because the rule of law is a culture. A society where the rule of law flourishes must be one that everyone accepts naturally, the obligation to abide by the law and knows the law. Therefore, educating the public on our constitutional order and the laws is important. We must also maintain high standards of the legal profession, in particular, the need to prepare our future generation of lawyers for a completely new landscape, a landscape that is shaped by the integration of Hong Kong's development with that of the mainland, the development plan for Greater Bay Area, the use of Chinese language where bilingualism is the norm, where globalization and rapid development of IT bring unprecedented demands, and where every member of the community expects access to justice. Hong Kong scores well in the Basic Law, in the Rule of Law Index of the World Justice Project. Despite social unrest, Hong Kong ranked 19th out of 140 countries in the world in 2021. But this year, it has fallen to 22nd. This is obviously because many Western media, under the control media system of their own countries, adopt a hostile attitude towards Hong Kong for the purpose of attacking the central government. We shall make efforts to explain to the international community the actual position, but we will not be threatened by the smearing tactics, because we know that we have a strong and effective legal system and the fabrics necessary to maintain the rule of law in Hong Kong. Apart from the opportunities Hong Kong may find in the Belt and Road Initiative and the Greater Bay Area Development Plan, Hong Kong may also share its experience in building up the rule of law in the countries along the Belt and Road and the Greater Bay Area and the cities along in the Greater Bay Area, as the rule of law is a necessary ingredient for economic success. I wish this conference every success. Thank you.
好多謝梁愛詩女士。剛才兩位咧都好詳盡，一個譚女士咧就係將基本法佢好多我諗佢當時記憶好深嘅一啲討論咧，就同大家分享。梁愛詩女士咧係好詳細，其實係講咗我哋香港普通法好多嘅細節，佢好似空氣一樣。大家已經慣咗，但係唔講呢，你唔記得咗。其實香港係一個好慷慨、好關心人權法治，亦都俾好多資源喺呢一方面。因為我都講，我自己都係立法會議員，我哋知道批幾多錢呢，喺呢一方面呢，係為咗維護香港嘅法治嘅。嗱，跟住我哋馬上呢，就係請范徐麗泰女士，佢就選擇呢，就係想企喺度講請。
尊敬的陈主任 Dr. the Honorable Priscilla Leung, Maria, Elsie, esteemed legal eagles, honorable guests, ladies and gentlemen. Hong Kong was under British rule for over 150 years, as you all know. But since the 1st of July 1997, Hong Kong Special Administrative Region, an integral part of the People's Republic of China, was established. I had the fortune of living and working in this place since 1949. And I must say, this is a wonderful place to be in. We have our ups and downs, but in retrospect, Hong Kong has always bounced back energetically. 尊敬的陈东主任 just told us that we have a wonderfully bright future. Let us once again, with efforts together, put Hong Kong back into this shining and wonderful place. Now, the last time I spoke on this topic, the executive, the legislature, and the judiciary, I divided Hong Kong's sort of history into two parts. Under the British rule, from 1981 to June 1997, and from July 1997 to present. Today, I propose to compare three periods: 1984 to 1983, the colonial period; 1984 to 1997, the transitional period; and 1997 to present, the SAR period, which of course will extend to many years to come. The colonial government, for more than 100 years, is led by the governor, who is a representative of the Queen, and he rules the land. He is the head of the administration, he is the head of the military, he is the president of the Legislative Council, with all members appointed by him, and he also appoints the Chief Justice. In 1984, when the Sino-British Joint Declaration was signed and the transitional period of 13 years commenced, we find that the first 8 years were passed relatively smoothly, with constant negotiation behind the doors between the two sovereign powers which was not made public, but resulted in agreements on the way forward. The foreign ministers of the People's Republic of China and the United Kingdom exchanged letters, the famous or infamous 7 letters, to seal this agreement on the political structure of Hong Kong, which ensured a smooth transition of the legislature. This resulted in more directly elected seats in the LegCo, but still retains the executive-led government. But everything changes in 1992, when the new governor, a British politician who lost his seat in the general election in UK, arrived in Hong Kong. He inherited an executive-led government, and through a winner-takes-all election, he succeeded in building up the influence of the opposition and weakened the government's hold on the governance of Hong Kong. However, the method he adopted contravenes the understanding reached between the 2 foreign ministers and ignored the composition of the first session of the legislature after the reunification. The through train of the legislature was thus derailed. Let me give you an example that in 1992, the governor is still the authority that is totally in control. In 1991, after the election in Hong Kong, LegCo established a committee to look into the election method. By mid-1992, the committee has reached consensus among other proposals that there should be 2 seats in each district, and each voter has 1 vote. 2 seats, 1 vote. This means that the most popular candidate and the second most popular candidate can both win the election. Naturally, such a proposal must and necessarily receive the acquiescence of the then administration. However, the new governor, when he arrived, did not like this. So it was changed to 2 seats, 2 votes. Just like that. And that facilitates a winner-takes-all situation. So the proposal of the committee was amended by amendment in LegCo. Another example was the splitting up of the Executive Council and the Legislative Council, and the reduction of the EXCO's role from explaining and supporting government policies to a think tank, an advisory role to the governor. There was no consultation of any kind. It simply happened. It was done at the pleasure of the governor. That is the period under colonial rule. And then, I should make an amendment. That was handed down from the colonial rule. But then, in the last 5 years of the transition period, with the joint declaration signed, the basic law promulgated, we now face the situation of the leaving, the departing government, putting every effort to ensure that there is an opposition when the new SAR government comes into force. So, as time draws near to 1997, 1st of July, the colonial government has more or less successfully lost control of the legislature. Actually, here you can see it all, but I'm just sort of explaining things to you. On political issues, the strong Democrats are allies of the colonial government. So both parties have something similar. They both doubt whether one country system could work. And both may well be downright anti-communism. On other matters, the administration, minus the governor, did not see things eye to eye with the Democrats. 7 pieces of labor law passed in the last days of the colonial legislature, which the last governor hastily signed into law just before his departure, were submitted by the administration to the provisional legislature right after the reunification to be repealed. The provisional legislature, with all members who were elected by the election committee, which elected the first chief executive of Hong Kong SAR, took pains to scrutinize these laws, repealed a couple of them, amended a couple for implementation, and suspended the enactment of the rest in order to study them in more detail. This is what the legislature is supposed to do. It is the responsible way in enacting law. And I, as president of PLC, have nothing to do with it because I don't participate in the Bills Committee or scrutiny of law. But this allows me to applaud the members of the Provisional Legislative Council for their endeavor. The role of the Legislative Council, Provisional Legislative Council, was to enact laws necessary for Hong Kong at that time. One of these laws was the law for the election of the first Legislative Council of Hong Kong. So now we finish this slide. Can we move on to the next slide? Thank you. So here, I apologize for some typo. It should be from 1998, 1st of July, to 2021, 30th of May. Now, from the first to the third legislature, there were small incidents, but by and large, bills do get passed with amendments. During the fourth and fifth legislature, use of languages imputing other members' motive or throwing objects, including glasses, at officials occurred. If I have to explain this change in attitude of some members, I think, among other things, there are 3 factors. First, members whose behavior were not suitable actually gets the media's attention without any criticism. Exposure on the local TV and media helped them to get more votes. In order to prolong their political career, their action and words become more and more theatrical until the legislative chamber deteriorates into a venue of bodily contact. Secondly, members of legislature and the chief executive were elected by different voters, therefore answerable to different audiences. There is not much common grounds between them, nor is there much basis for cooperation. Thirdly, and perhaps more importantly, many voters in Hong Kong were influenced by half-truth and fabricated news in the media and on the internet. While some playfully, I stress, elected legislative members because they like to see the show of members admonishing officials, others were simply brainwashed to be anti-government. The situation worsened in the 6th legislature, with filibusters inside legislature blocking government proposals and demonstration outside legislature, turning violent and brought about destructions to property, attack on government building, policemen, and anyone who dares to speak up against them. Or to help anyone who dared to help to put things back to order, like cleaning the obstacle on the street. They were attacked. By 2020, it becomes clear that those members of legislature using every possible means to halt the council's business are anti-China. They proved this by going to the United States to seek help in sanctioning Hong Kong SAR officials and Chinese officials. The mob in the streets were calling for independence of Hong Kong. Normal citizens of Hong Kong faced riot, damage to the property, loss of personal freedom, fear of financial and bodily harm, and infringement on their freedom of movement and speech. The concept of executive-led government is no longer viable. We have to return to the executive-led government as envisaged in the Basic Law. So in March 2021, the National People's Congress decided to amend Annex 1 and 2 of the Basic Law, which deals with the election of the Chief Executive and the legislature. The Standing Committee then proceeded to work out a more detailed plan, which the SAR government put into effect through passage of the bill through LegCo. So as you can see here, it's all here. Now, I move to the judiciary. As you can see, before the reunification, the Court of Appeal, as everybody knows, is in London, which is the Privy Council. And maybe not many of you will know that in 1979, the governor of Hong Kong appointed the then Chief Secretary to be the Chief Justice. And that Chief Justice retired in 1988. Independence of the judiciary? Maybe, I don't know. I would not wish to put names anyway. But that certainly is, fortunately, it never happened again in Hong Kong history. And in those days, most of the cases before the courts are of commercial or criminal nature, very few judicial reviews. But after 1997, July the 1st, the Court of Appeal is in Hong Kong. And their decision cannot be overturned unless it concerns the duties, the responsibilities of the central government or the relationship between the central government and the Hong Kong SAR. All CJs are Chinese origin and they did not serve in the executive arm of the government. There are many more cases of judicial review since 1997, and most of them are granted legal aid. The important thing is, which I think our previous speaker referred to, all the courts in Hong Kong may interpret articles in the Basic Law, except the two areas I mentioned. So the judiciary's influence on Hong Kong actually has been moving upwards, which is good. We want law and order in Hong Kong. We want a very, very impartial and yet just judiciary. So with this, I thank you for your attention.
好多謝范徐麗泰女士。我哋咧就係其實一直就好欣賞佢咧主持立法會嗰個時間嘅。我係08年加入立法會。喺我再繼續講之前呢，我自己頭先試咗個同聲傳譯，我真的很想推薦大家用。第一呢，今天的同聲傳譯是我搞那麼多次國際研討會最高水平的，所以呢都是在政府在基本法起草期間幫我們做同聲傳譯，所以我自己專門用了一下，是翻譯的普通話、廣東話和英語都非常好，所以大家想有時候也舒服一點呢，用你的母語也用一下，就是真的是非常出色。好，我呢就想講一樣嘢啦，我就係2008年加入立法會，佢向范太請教咗無數咁多次，即係點解我哋嘅立法會會出現咁嘅問題？而喺08年啦，我記得我自己已經提咧，就係紅牌黃牌制啦。咁其實呢個係醜死怪嘅，本來就唔需要嘅。我哋以前就係立法會係一個好 civilized、好文明嘅一個地方。但係我自己做咗14年立法會議員咧，我自己本人係睇到立法會喺如果你一旦放縱啊，即係我哋中國人講一個度啊，一放縱過咗個度咧，咁就 backfire 啦，就係 所以先至會導致呢，頭先范太講啦，2020年我哋要有港區國安法，2021年要改善個選舉工程。咁點解呢？我就應該屬於係受害人之一，但係全個香港社會係最大嘅受害人，因為我哋已經去到一步，我哋無法開會，無法通過財政預算案，我哋連衛生安全都符合唔到，因為喺香港抗疫防疫嘅期間，都一樣可以呢，就係帶一啲呢係帶有可能極度危險嘅對衛生嘅情況掟入去嗰個議事廳，大家係好無助。我哋唔應該無助，人哋係向我哋求助，結果立法會係幾乎係癱瘓。大家試想想，立法會癱瘓就即係香港癱瘓，因為我哋無法做任何嘅事，就係 no money no talk 啊！個 talk 就係連喺嗰度企喺度都冇辦法 talk 啦，因為完全係冇 public money 可以用 ，public hospital cannot work。Public education, public housing, everything can be put into paralyze. So that's why we have to amend our election system. And I am now also another beneficiary of the amendment because now we can have normal life in Hong Kong. We can have this conference with safety, and our foreign guests can be here and need not worry to outside with 5 securities here because we come back to normal life. So this is really my personal experience. I love everything in Hong Kong. I was born here. And what actually Ms. Elsie Leung has just shared with us, I hope everyone can pay attention to all the details with actually our legal aid system, and all this confidentiality to lawyers, everything is actually the niche of Hong Kong. And Ms. Maria Tam has shared with us Deng Xiaoping's speech that we never pay attention when we taught, but it has caught much more attention this year and last year, especially when we experienced what had happened from 2019 to 2020. So we really admire the wisdom and the foresight of our former paramount leaders, the late Mr. Deng Xiaoping, and also our present leader from the speeches of Xi Jinping. They both carry this foresight, and also, of course, to keep Hong Kong stable and prosperous. We have all these generations of leaders, and the one, of course, including our very admired leader, Mr. Jiang Zemin, who has just passed away. And he was the one who participated in the ceremony of Hong Kong handover at 0.02 July 1st, 1997. Okay, I think all the 3 ladies were there in the photo, of a very memorable photo I saw once. Those people who have the standing to participate in that ceremony. It's a great thing for the world. And we hope that this one country, 2 system could work to solve another very big, outstanding issue for China, for our reunification. And if they accept one country, 2 system, we can have a very good, peaceful reunification. And that is the efforts of all Hong Kong people. We have to prove ourselves that one country, 2 system works so well. We actually also benefit and have a very good example for the world. So I think this section, we all benefit from the great wisdom of our drafter, our former president, who keep law and order, the rule of procedure. You sit down. So long hair was under her hand, and did not, and very guai, very obedient. we are in the pool. We really appreciate that kind of wisdom to just keep the equilibrium. We have to allow freedom of speech. All legislators want to speak without stop. Like now, I'm holding the microphone. I will stop very soon. Okay. But long hair also listen when he really disciplined. Okay. And Miss Elsie Leung, I have to say, I witnessed her fight so many battles to uphold rule of law in Hong Kong. And she adheres to international principles, suffered a lot of unnecessary and unfair attacks, and still stay firm. So they are all my very respectable teachers. And we would go on. We would keep this fire to make Hong Kong under one country, two systems, brighter and more beautiful than before and ever. Okay? Many are lawyers. I think we should make effort to that. And now I would like to take the opportunity to send some books signed by a professor who is going to speak as the second speaker for these three prestigious speakers.
我哋再一次俾掌聲，梁美芬博士同埋我哋咁多位台上嘅分享嘉賓，咁亦都有請咧梁博士咧為我哋將一個嘅紀念狀啦，同埋一個嘅著作咧係送俾我哋3位嘅講者嘅。咁有請譚慧珠大紫荊婚宴、梁愛詩大紫荊婚宴同埋范徐麗泰大紫荊婚宴接受。呢本嘅著作咧就係、中華傳統文化現有下的視覺下的國際經濟法，咁係由黃貴國教授注寫嘅。咁亦都有請3位啦，我哋攞住我哋嘅著作啦，同埋我哋嘅紀念狀啦，我哋一齊影一張合照，有請。好，我们再次以掌声感谢梁美芬博士，还有我们3位的主讲嘉宾陶慧珠大紫荆勋爷、梁爱士大紫荆勋爷，还有范徐丽泰大紫荆勋爷，为我们做出了精彩的分享，感谢。咁今日我哋非常之係榮幸啦，邀請到咁多位重量級嘅分享嘉賓嚟到我哋當中。咁我哋咧都再次有請我哋3位嘅分享嘉賓，以及梁美芬博士咧，我哋再影多張合照。可能我哋向地下少少，咁就唔會反光啦。咁可以影到一張最完美嘅合照。再一次感謝咁多位，亦都唔該晒梁美芬博士為我哋主持咗我哋今日第一個環節嘅討論，多謝晒。好啦，緊接落嚟呢，就去到進入我哋第2個環節，有關一帶一路與全球經濟、地緣政治及文化嘅一個論壇啦。
We will now begin the second session on the theme of One Belt One Road and global economy, geopolitics and culture.
咁而喺第二節嘅論壇呢，我哋好榮幸可以邀請到2位嘅主持人啦，同埋4位嘅演講嘉賓嘅。咁我哋嘅主持呢，係包括咗有全國人大常委會香港特別行政區基本法委員會委員陳宏毅教授。
Our first speaker will be Professor Albert Chen Hung-yi, member of the Hong Kong SAR Basel Committee of the MPCSC.
冇錯啦，而我哋另一位嘅主持人呢，就係前香港特別行政區律政專員馮華健資深大律師 SBSJP。
And second speaker will be Mr. Daniel Fong SC, former Secretary General of the Hong Kong SAR.
冇錯啦，咁亦都有請我哋嘅主講嘉賓呢，可以移步同樣呢係嚟到台上，咁我哋都為大家介紹一下我哋呢個環節嘅分享嘉賓先，分別有前香港特別行政區律政司司長、最高人民法院國際商事專家委員會委員、香港國際仲裁中心聯席主席袁國強大紫荊婚宴 SCJP。
May we also welcome the Honourable Rimsky Yuan Guokeng SCJP, former Secretary for Justice of the Hong Kong SAR and member of the International Commercial Expert Committee of the Supreme People's Court and co-chairman of Hong Kong International Arbitration Centre.
另一位嘅分享嘉賓就係浙江大學國際戰略與法律研究院院長黃貴國教授。
The next guest is Professor Wang Guiguo, President of the Zhejiang University Academy of International Strategy and Law of China. And may we also welcome Dr. Rajesh Sharma, Senior Lecturer of RMIT University of Australia.
冇錯，亦都有請澳大利亞皇家墨爾本理工大學高級講師 Dr. Rajesh Sharma.
May we next welcome Professor Kashif Iramzadi, Associate Professor. May we next welcome Professor Kashif Iramzadi, Associate Professor, Dean and Director of the School of Law Policy, University of Management of Technology from Lahore, Pakistan.
亦都有巴基斯坦拉合爾管理技術大學法律與政策學院副教授同埋院長 Kashif Iramzadi。我哋有請我哋嘅咁多位嘅分享嘉賓呢，係可以一齊移步嚟到台上啦。我哋再次有請我哋呢個環節嘅兩位主持啦，分別係陳雲毅教授、馮華健資深大律師，同埋我哋咁多位嘅分享嘉賓呢，可以齊集嚟到台上啦。呢個環節呢，我哋有好多位嘅學術啦，我哋喺嘅學者啦，都嚟到我哋當中。咁呢個環節亦都有兩位嘅主持人呢，係為我哋作出主持嘅。咁所以呢，大家呢都可以耐心等候啦。我哋稍後呢就會正式開始我哋第二個環節㗎啦。咁亦都再次提醒各位啦，喺我哋呢一個嘅場館裏邊呢，係不能夠飲食嘅。咁如果大家有需要飲食嘅話呢，或者飲水嘅話呢，喺我哋旁邊嘅 Ballroom 4嗰度呢，係會有呢啲嘅水呢準備咗俾大家。咁大家呢陣間可以係 break 啦，又或者係 lunch break 嘅時候呢，移步去到 Ballroom 4嗰度呢。咁我哋都準備咗一啲嘅清水啦，嗰度有水係提供俾大家。不過我哋呢一個嘅 Ballroom 裏邊呢，就邀請大家就切勿飲食啦。咁都係防疫嘅關係，希望大家呢都可以一齊合作啦。
For those who need some refreshments, some water is provided at Ballroom 4 down the corridor, but there's one reminder, no food and drinks are allowed here, so please finish your drink before you come back.
好，咁完啦呢個時間呢，我哋都正式將呢一個嘅舞台交俾我哋兩位嘅主持陳雲毅教授同埋馮華健資深大律師，為我哋主持第二個環節嘅討論。我哋將時間交俾兩位。
多謝多謝大家翻返嚟參加我哋呢個研討會嘅第二個環節。咁我就用英文主持呢個環節啦，因為有啲係即係外國嘅嘉賓嘅講者。So I'm very pleased to moderate this session together with Mr. Daniel Fung, SC. So the two of us will be responsible for introducing the speakers and also giving some brief comments on their speeches. So the first session, the opening session, has already dealt with some macro perspectives regarding the general constitutional framework of one country, two systems, and the rule of law infrastructure in the Hong Kong SAR. Now, this session will focus more directly on the theme of the conference. As you know, the conference is on One Country, Two Systems and the Belt and Road Initiative, an international conference. So in this session, this morning, we will be looking at the topic of the One Belt, One Road and the global economy, geopolitics, and culture. So we are very pleased that the 4 very distinguished speakers have agreed to speak at this session. So I'll introduce each of the first 2 speakers before they speak, and then Mr. Daniel Fong SC will introduce the 3rd and the 4th speakers before they speak. Actually, the first speaker needs no introduction. He is Mr. Rimsky-Yuen SC, the former Secretary of Justice of the Hong Kong SAR. And he is also a member of the International Commercial Expert Committee of the Supreme People's Court of China and co-chairman of the Hong Kong International Arbitration Center. So he's very well known in both the legal community and in the Hong Kong community generally. Most distinguished barrister. And he will be speaking on the topic of the role of Hong Kong under the Belt and Road Initiative, a legal perspective. So may I hand over to Mr. Yuen. Thank you.
Distinguished guests, ladies and gentlemen, good morning. First of all, may I express my gratitude to the organizer, the Hong Kong Basic Law Education Association, for giving me this opportunity to participate in this event and to share with you some of my personal thoughts on the topic in question, namely the role of Hong Kong under the Belt and Road Initiative, a legal perspective. The Belt and Road Initiative has been described as the project of the century. From any angle, the Belt and Road Initiative is a massive initiative affecting a massive number of people and involving trillions of investments and trades. With the support of the Central People's Government, Hong Kong has been very lucky to have huge and diverse opportunities to participate in the Belt and Road Initiative. The question posed by the organizer to me, namely the role of Hong Kong in the context of the Belt and Road Initiative from the legal perspective, is a question that merits serious consideration and research. As almost a decade has passed since the Belt and Road Initiative was first announced in 2013, it is indeed an apposite moment to revisit this question by reference to past experience as well as by looking into the future. In addressing this question, one of the possible approaches is to identify the key features of the Belt and Road Initiative, and then to examine in what ways Hong Kong can make use of her strengths and edges to further promote the implementation of the Belt and Road Initiative. Adopting this approach, a natural starting point is the 5 major objectives of the Belt and Road Initiative, namely policy coordination, facilities connectivity, unimpeded trade, financial integration, and people-to-people bonding. All these major objectives, in a way, boils down to connectivity in one form or another. Connectivity, however, cannot be built in a vacuum. Hardware, including infrastructure such as railways and highways, are certainly essential. On the other hand, software support, whether in the form of bilateral arrangement or multilateral framework, are equally essential, especially when one considers the long-term sustainable development of the Belt and Road Initiative. Another key feature of the Belt and Road Initiative is the absence of an overarching framework arrangement or multilateral instruments. Unlike other arrangements, such as the former TPP, the Trans-Pacific Partnership, or the current Comprehensive and Progressive Agreement for Trans-Pacific Partnership, countries or regions which want to participate in the Belt and Road Initiative are not required to enter into or sign any overreaching or multilateral instrument. The absence of such an overarching instrument means flexibility. However, at the same time, it poses challenge in the building of connectivity. A third feature of the Belt and Road Initiative is the fact that the different countries and regions that participate in the Belt and Road Initiative have very different legal and judicial systems. In one sense, this means plenty of choices to the end users. In another sense, however, this may mean complexity and uncertainty when legal issues arise. With these key features of the Belt and Road Initiative in mind, the next question is what role can or should Hong Kong play? From the legal perspective, which is the perspective I'm asked to address this question, the answer that I would venture to suggest is that Hong Kong can play a very unique and potentially important role in the context of the Belt and Road Initiative. Thanks to the one country, two system principle, Hong Kong is unique in that it is the only common law jurisdiction within the territory of China. Hong Kong also enjoys the best of both worlds, in that on the one hand, Hong Kong has been and remains an international city with strong ties with different countries in different regions. Apart from the international business community, Hong Kong is the rendezvous of the international legal community. On the other hand, whilst being international, Hong Kong has a strong connection with and enjoys the solid support of the mainland. One of the combined results is that Hong Kong has been a well-recognized international legal and dispute resolution center in the Asia-Pacific region and beyond. With these strong fundamentals, I will venture to suggest that Hong Kong can consider playing an important or even leading role in at least the following areas. First, Hong Kong can be a platform or a center for facilitating and enhancing mutual understanding of the different legal and judicial systems among countries and regions participating in the Belt and Road initiatives. Such mutual understanding is of particular importance in the promotion of trade and human connectivity. In the past, for instance, financial due diligence was regarded as essential before one finalized a deal. Now, legal due diligence is regarded as equally important in any major commercial or investment transaction. Will there thus a better mutual understanding of each other's legal and judicial system will certainly facilitate trade and other forms of human activities. Second, Hong Kong can serve as an ideal venue for resolving disputes amongst the Belt and Road jurisdictions. Disputes are inevitable in the course of conducting cross-border trade or transnational investment. A robust means of resolving dispute in a fair expeditious and cost-efficient manner is important both from the perspective of building a rule-based international trade environment in the Belt and Road Initiative context, as well as generally in the context of the rule of law. For decades, Hong Kong has been developing a regime of effective dispute resolution which is well received by international community. The existence of comprehensive legislative framework for arbitration and mediation, the presence of well-known arbitration institutions such as the Hong Kong International Arbitration Center, and the presence of extensive pool of talents, including arbitrators, mediators, legal advisors, together with other supporting service providers, are some of the factors which make Hong Kong an internationally well-recognized dispute resolution center. With her vast experience in dispute resolution and her independent judiciary, there cannot be any doubt that Hong Kong can serve as the ideal center for resolving disputes arising from the Belt and Road trade and investment activities. Third, technology plays an important role in the development of trade and investment. Blockchain, cryptocurrency, artificial intelligence, and smart contracts are popular topics in the international business community, and their impact on international trade is a topic that no jurisdiction can afford to ignore. No doubt, these technological developments will have as far-reaching consequence as the construction of physical infrastructure. Hong Kong is now building her strengths in this area. With Hong Kong's experience in legal matters, coupled with the expertise and support of the mainland, there is no reason why Hong Kong cannot seek to play an important role in building a transnational legal guideline, whether in the nature of a model law or best practices in the Belt and Road context. Fourth, climate control and green finance are another popular topic at both the international and domestic levels. Green finance, likewise, cannot take place in a vacuum. The support of a robust legal infrastructure and certification are likewise very important. With Hong Kong's recent development in this area, and with Hong Kong's legal and investment expertise, this is, I believe, another area where Hong Kong can endeavor to play an important role in the Belt and Road context. Among others, Hong Kong can join hands with other jurisdictions to hammer out model transactional documents or pro forma contractual clauses for the relevant parties' reference so as to facilitate the conduct of green financing in an efficient manner, as well as to avoid unnecessary disputes. On this note, it remains for me to wish this conference every success and to wish all of you a very enjoyable weekend. Thank you.
Thank you very much, Rimsky, for a very insightful discussion of Hong Kong's role in the context of the Belt and Road Initiative. Mr. Yuen, in particular, highlighted 4 particular roles which Hong Kong can perform in relation to promoting mutual understanding, serving as a center for dispute resolution, promoting guidelines or model laws or best practices in relation to technology-related developments, and also playing a role in the context of climate control and green finance. So, since time is limited, I will not give further comments at this point. We will now turn to our second speaker of this session, Professor Wang Guiguo, who is currently president of the Zhejiang University Academy of International Strategy and Law. Professor Wang has been a long-serving professor at the City University of Hong Kong and has served as Dean of the Law School of City University for many years. And his scholarship on international economic law is very well known. So I suppose, is Professor Wang speaking online with us?
Okay, thank you very much, Albert, and thank you for the introduction. I wonder if you can hear me over there.
Yes, very clearly.
Thank you very much, and also in the first place, thank you very much for inviting me to join this conference. I'm very honored to speak to this very distinguished audience. I have my PowerPoint. I'm told that the technicians here will help me. Please turn on. I can't see the. Can you, Albert? Can you see the PowerPoint?
Only the cover page.
Okay. Please turn on to the next page. Please, can you see it?
No.
I can easily share it myself, but I'm told.
Yes, we can now see the page with the challenge.
Okay, very good, very good. Thank you very much, Albert, and let me know if there is any problem since the PowerPoint is in English, and I heard that we have very good simultaneous interpreters. Most probably, I will speak in Chinese and I'll try to finish in about 10 to 15 minutes, if possible. 我想呢，今天我想讲的题目是，一带一路10年，第一个10年，它的法律挑战及应对。我想首先，我们看到就是一带一路是在一个什么背景下产生的？我自己认为，一带一路是经济全球化的一个结果，是适应了经济全球化。那么在这个10年的过程当中，一带一路取得了很大的成就，同时也有很多挑战。这些挑战就包括在10年的发展过程当中，国与国之间的关系，就是相对地位发生了变化。这个主要是中国和美国，以及中国和其他国家。那在这种情况下，应该如何应对，构成一个新的挑战。第二个挑战是，在过去的10年过程当中，由于科学技术的发展，特别是与网络技术和数字经济相关的这些科技的发展，使得国际决策、国际决定，或者说国际法与国际法相关的政策决定的参与者扩大了。过去呢，我们这些参与者主要是国家和国际组织。现在呢，我们想看到呢，除了国家、国际组织、非政府组织、企业，甚至是个人，在国际决策当中都可以起到非常重要的作用。第三个方面是，我们经济交易和交往的内容模式发生了巨大的变化。比较显著的就是包括线网，就是这个网购或者线上的交易。那这个呢，不仅仅是线上的交易，同时它也直接影响到，比如说这个金融服务的模式，也影响到运输，甚至是仓储以及消费者的消费等等。 第4个方面的挑战，我认为就是美国一直以来将自己呢视为一个很特殊的国家，我这里把它叫 exceptionalism。那所以由于他自己的特别，就把自己国家的利益作为最重要的利益，也就是凌驾于世界其他国家的利益。这个呢，对国际法就构成了一个最大的影响。那么影响的结果，也就是说，我们会看到对国家主权这个国际法例外的原则的滥用。那么同时呢，这也就导致对其他国际法基本原则的重要影响。请翻到下一页。那么这些影响都有什么重要的方面？我想呢，简单的讲，也就是看到呢，由于这些前面的这些挑战，使得现有的国际法的规则，有相当大的表现出相当大的局限性。一个就是国家主权。那么现在国家主权呢，显然已经不是过去国家主权的意义，它延伸到这个，比如说这网络主权、数据主权、食物主权、能源主权，甚至是病毒的主权等等。那这些问题怎么去解决？现有的习惯国际法、现有的条约法，显然都不可能这个涵盖所有的这些领域。这就出现一个新的问题，也就是在目前这种情况下，应该如何应对现有的情况。我的一个基本的判断应该是，随着世界情况的形势的发展，那国际法和国际规则也必须与时俱进，这也就是世界面临的一个新的形势。请翻到下一页。正是在这种情况之下，我认为“一带一路”是有很大的可操作性，因为“一带一路”走到今天，和国家提出的人类命运共同体，应该是有很好的契合。那为了推动“一带一路”，特别是使国际秩序、国际法规则能与时俱进，那我们必须要对现有的规则提出一些见解，提出一些建议，使现有的秩序和规则能更适合国际社会的发展。在这方面，我认为中国在推动“一带一路”的过程当中，应该强调如何将中华传统文化的优秀部分适用到国际社会，适用到国际秩序的与时俱进改进方面。那当然呢，我们在推动“一带一路”秩序的过程当中，我们并不是说要重新建一个新的制度，而是对现有制度进行必要的改正、必要的改进。那么这也就是呢，我们传统文化里边讲的“万物并育而不相害，道并行而不相悖”。请翻到下一页。在这个基础之上，我认为在推动“一带一路”的过程当中，我们应该和国际社会目前的这个努力相一致，也就是国际社会现在推动的是在国际层面和国家层面实现法治，建立法治制度。那在这方面，我们的传统文化当中有很好的值得借鉴的方面，我在这里只简单的讲几个。一个就是无论是从儒家也好，从道家也好，还是从法家也好，大家都主张一定要有规则。那比如说孔子曾经说过，能以礼让为国乎？何有不能以礼让为国？如礼何？如果没有 没有礼，在当时那就是法律。如果没有法律，他说你这个国家怎么去治理？那么接下来呢，荀子就提出来，他说治国不以礼，由无居而礼也；为礼不本于义，而有礼而弗种也。他的意思就是说，如果你治理一个国家不讲礼，不讲规则，那就好像你耕地没有犁一样。那么说这个规则应该反映什么呢？应该反映的是正义的原则。如果不能反映正义的原则，那么就好像你种地没有种子一样。那么大家认为呢？说只有如此，才可以使人尽自己的人性，物尽自己的物性，那世界呢才能够成为一个和平的世界。请翻到下一页。那么在这个情况之下，我觉得呢，就是我这出现了一点问题啊。那我想，香港能做什么？刚才国强司长也讲到这个问题。我觉得在推进法治的过程当中，一个很重要的方面，那么就是如何制定法律。中华传统文化就提出来，他说法不能独立，类不能自行，也就是说法律不可能自己独立，那些判例也不能自我的实现，而呢靠人。如果有了人，有了适当的人，即使你的法律不是很完善，也可以应对一些这个突然出现的事项，那也可以使法律能够发挥治理的效果。请翻到下一页，也就是最后的这一页。那么这里呢，我们就说，在这种情况下，那香港可以做什么？我觉得前面几位讲者，包括陈东副主任，对香港是一个法治社会，香港的普通法的作用都已经讲了很多，我在这里不再重述。那我想提到一点的就是，香港本身是一个市场经济非常完善的经济体，而呢在国际经济交往当中，市场经济至今仍然是国际社会交往的一个基础。只有这样一个基础，我们才可以说在这个基础之上做这个 finance。那么香港呢又是航运，就是国际金融中心，又是航运中心。香港的普通法恰恰呢，无论是在程序方面，在实体方面，都在国际上得到广泛的应用。在这种情况下，我认为香港本身就有非常好的条件，再加上香港正在通过大湾区融入国家的经济建设，那么从而呢，依据以大湾区作为一个背景，香港面向世界，以法治和金融作为手段，以市场经济作为基础，一定能发挥很大的作用，为国家的建设，为人类的福祉，包括人类的尊严和世界和平做出重要的贡献。谢谢。
Thank you, Gui Guo. Professor Wang's speech is, I think, inspiring because he refers to the role of traditional Chinese culture and also Hong Kong's possible contribution to the Belt and Road Initiative. And in particular, he highlights the changing business and technological environment in which international law now faces challenges, and he believes that international law needs to adapt to the new environment. And in this respect, certain traditional Chinese ideas and philosophies can make a very useful contribution in this regard. So I'll now hand over to the co-chairman of this session, Mr. Daniel Fong, SC. He is a very distinguished barrister in Hong Kong, a long-serving member of the CPPCC, the Chinese People's Political Consultative Conference. And I also remember him very well as the first Solicitor General in the Hong Kong SAR when Mr. Tong Chi-hua was Chief Executive. So Daniel, may I hand over to you?
Thank you very much, Albert. And it gives me great pleasure to introduce the first of the next two speakers, Dr. Rajesh Sharma, who is much beloved and has made enormous contributions to City University Law School over the past 20-odd years. We have sadly lost Dr. Sharma to greener pastures. He is now with the RMIT University in Australia, but we're delighted to welcome him back to Hong Kong to participate in this very important conference. And I wish also to express my gratitude to Dr. Priscilla Leung and the organizers of this very important event. So, Dr. Sharma, the floor is yours.
Thank you, Mr. Fung. Dr. Leung, thank you very much for inviting me and coming here again in Hong Kong and taking part in this conference. I should say that I have taken part in the 5th anniversary, 10th anniversary, 15th anniversary, and 20th anniversary. And I'm sure I will participate, come back again in 25th anniversary. So I will be coming there. Before me, everybody in the first session, they said they enjoyed staying in Hong Kong. They love Hong Kong because they are born in Hong Kong. I can tell you, unfortunately, my mom didn't come to Hong Kong to give me birth here. So I was born in India. But when I had an opportunity to come, I came here in 1995. And I have seen Hong Kong since 1995. And even if when I left Hong Kong, my heart and my one leg was always in Hong Kong. So I have lived through it, and I have seen all those things. When the three beautiful ladies sitting here and discussing about it, my colleague from Bangladesh, she said that this stage is so powerful that we have three women who have taken part in developing the law, a rule, a system in Hong Kong, in constitutional debate and constitutional making. They are sitting here, and we discuss. And I told her that now we are talking about women in law, women in arbitration, and these ladies have already done it long time back. So this was a déjà vu moment for me. And these legends who are sitting here, I had an honor to take photo with me and with them, and I folded hand. I told them that it is my real honor to stand with them. I don't feel that I really deserve to be here with this league of people. So what they told you about what Hong Kong, the role of Hong Kong, they are the torch bearers. They have done much better. What I'm going to tell you is, as a person who lived in Hong Kong and now is outside dealing with the international community, I want to tell you that how I feel about the Belt and Road, how I feel about the one country, two system, and how I feel about that, how these two can combine together. So this is my thing to talk to you. If I go to the next slide, please. My next slide, please. Thank you. Yes. Now the Belt and Road development, which everybody is looking at it as a different aspect, that is a connectivity. It is infrastructure. I come from a developing country, and I have lived here in many other countries, and I have traveled. I can tell you the Belt and Road, initiative which you are seeing, you should not see it from just connectivity part. Imagine in this room, while we are discussing here, suddenly the light goes off and we do not have electricity. What will happen in this room? You can't even imagine. And I'm sure many young generation can't even imagine that there are many parts of the world, including in my country, before and even now, that we studied in the night, in candlelight, in kerosene lamp, because we didn't have electricity. Many places in those countries where you have to think about it, that because of no bridge, the woman has to deliver baby and they have to go 10 kilometers around, and by the time they reach to hospital, baby dies or the mother is in trouble. You have to think about the places where we do not have a school, we do not have public health system. Forget about the health system, we don't even have a hospital, a building. And now we are talking about those countries. So Belt and Road is not just a connectivity. Belt and Road Initiative for the power project and all those things is something different and something very unique. How it started? If you look at that, not the concept it came from China, but it was debated in United Nations, in General Assembly, and it was said that the right to development is our individual right. And when we move forward, it becomes the added and connected with the human right. So the right of development is there, and right of development for individual is very important in that sense. And I'm looking at these kind of investment, these kind of development. If we can go to the next slide, please. So the one concept, and these lawyers can tell you that, and you know that, if I have a right to develop, the important part is that who has a duty to develop me? Who has a duty to support me? Just having right is not important. We need duty. So this United Nations resolution did one very good thing, is that, and this is one of the few legislation or few guidelines where you find that where the government, the state, has given this power and duty to help assist their citizens for right of development. Now, if you look at in that case, even if I'm coming from a country, I have a right of development, my government has no capacity. So what's the point? Even if I have a right, how this right can be exercised? So the Belt and Road Initiative is not just related to one country. Belt and Road concept is accepting and including all individuals from all countries, recognizing their right of development, and it has been assisted by the government or Chinese initiative that it has given us some kind of development, some kind of movement on that. We have traveled to Papua New Guinea, Samoa, Phillip Island, all these are small countries. If you go there, now they have a road, is because of this Belt and Road Initiative. So this is the beauty of that Belt and Road Initiative. If we go to the next slide, please. Next slide. And this is the benefit I'm talking about. All these benefits which we have because of this Belt and Road. We were traveling in Papua New Guinea. We went to very, very far end. And at that time, we realized that if we wanted to get a water bottle, if we want to get something, we thought that there's no shop here. And when we went there, we found that there was a big shopping mall run by the Chinese company over there. And we talked to the local people and said that, what do you feel about it? They said that ever since this shop has opened, at least we have our basic needs are meeting here and we are surviving. So this is the part of it. This is the benefit we are looking at. But the problem is, most of the time when the benefit is given, people do not look at that, and it is tangled with the politics. And I give an example. My colleague Kasif is here. One great example of Belt and Road is a CPAC. CPAC, a road which is being built from China to Pakistan. But part of the road is traveling through India. Now, of course, the Indian government is a disputed territory, so that they say that they are not supporting. But when we look at it, we don't look at the road as a territory or anything. We look at the road which is giving this benefit to the people in that area. Now at least they have a road that they can travel. They can access to the market. They can go to the hospital. They can go to a school. This is what we are looking at. And this is the benefit of that. Just because road starts from Pakistan, crosses one part of India and goes again another part of Pakistan or China, that doesn't mean half of the road is legal and the part of the road is illegal and then another part is legal. That cannot work like that. When we are traveling, it is useful for everyone. So these are the benefits. We look at that and we don't see it through the geopolitics or political lens. If I may go to the next slide, please. So the politics is disturbing, but apart from the politics, when WTO negotiation was done in 1986, very good rules were made. But at the end of the day, everybody discussed and said, what's the point of having a good rule if we cannot get the benefit from there? And why we cannot get the benefit is because of the not having a good dispute resolution mechanism. So a phrase was coined, and it said that without a good dispute resolution mechanism, we cannot have a good system, and the benefits of the agreement cannot be reached to the benefit to the local people or to the people at the ground. So if the Belt and Road is intended to give the benefit to the local people, the people on the ground, then we must have a good dispute resolution system. When we say good, it means it should be effective, it should be efficient, and it should be practical. And that's the system we want. So please, next slide. So in this one, what could be the role of Hong Kong? Mr. Yun has already told you everything about arbitration. That everybody knows. But what I want you to remind you that when I came in 1995, I learned about the arbitration in Hong Kong, and at that time, HKISC was the leading center in Asia. And remind you, at that time, Singapore was not there, Kuala Lumpur was not there, Vietnam was not there. Actually, the Hong Kong was giving assistance to Vietnam in the project where I was part of it to establish the arbitration center over there. Singapore was learning from Hong Kong at that time. We have forgotten that. We have to remember again. So the seat of arbitration as Hong Kong is not disputed, very well recognized, and it is already there. But what is important is 1997, when the New York Convention could not be applied between Hong Kong and China. Ms. Elsie Leung is not here. She was the one who was running to China all the time and come up with the new idea to have a reciprocal arrangement between China and Hong Kong, and the problem was solved. And at that time, and since then, Hong Kong back to normal, and the arbitration center is working very well. So I don't have to say anything on that. Next slide, please. Next slide. Yes. Now, this is the one. After the arbitration established in Hong Kong, you remember in 1997 again when the Court of Final Appeal came at that time, then Chief Justice came up with the idea that we should have a mediation in Hong Kong, and the first family mediation started at that time. Interestingly, since then, Hong Kong has now established itself very well as a mediation center, as a part of mediation, and that is what very normal because of the culture is there for the mediation. But for last 5-7 years, I can tell you that Hong Kong has done very well in really coming out and establishing it. And I have seen it from my own experience. Again, Dr. Francis Law is here. Our former Secretary for Law is here, Justice. They have been working all around, going everywhere, taking part in the UNCITRAL work, and actually you have brought the UNCITRAL to Hong Kong also, in many participation on that. This mediation is now picking up very well, and the Hong Kong has a very good role to play on that one. And now the new decision that the Hong Kong Mediation Preparatory Office will be open here, and that will be again the game changer. And we are saying that we have to ride on that, and we have to establish. So Hong Kong's participation in arranging or negotiating the Singapore Convention, which is like New York Convention for enforcement of settlement agreement, is another game changer. Another game changer, and we have to work on that. So the mediation is also a very good way to resolve the dispute, and it can be used for the Belt and Road system without any problem. So what we need to do is that this Singapore Convention has to be extended to Hong Kong. And we need the same kind of mutual recognition arrangement between Hong Kong, China, Hong Kong, Macau, China, Macau, those kind of things we have to do it. So in that way, the mediation center will really work. All the centers is doing very well, and we can work it very nicely on that. Another thing, the Hong Kong also needs to sign MOUs and all those agreements with different institutions, and that will help us in the meantime to execute our implementation of Singapore Convention. So the next slide, please. Rule of law, Mr. Elsie Leong has already talked about that. I don't have to say anything more on that. Rule of law and in Hong Kong is well established. And all the cases which you have seen, common law, non-disputed. Outside also people understand that, they recognize it. So we don't have to do anything about it. Rule of law has really established about that. So it's all these things are there. So go to the next slide, please. And that will be my last slide. And I'm sure everybody is waiting for hearing my word, that is my conclusion. The only thing I have to say that what we have to do now. Over the past few years, when we are seeing Hong Kong from outside and what we communicate with other international groups and organizations, the one thing is that Hong Kong has to re-energize itself, reinvigorate itself. Now we have to come back to the same place where we were before. It means now we have to go out and tell the people that where the Hong Kong is, it is still good, still strong. So all these negative media, negative information which is out there, we have to clear that. If that thing is clear, then it will be very fine, no problem in that one. So this is the one thing we need. And as I told you, the second thing immediately, which is easy to do, now the path is open, we should ask the central government to extend the Singapore Convention to Hong Kong so that Hong Kong can start doing its business or use the mediation with other partners. That will be there. And we should immediately work on the implementation of Singapore Convention between Hong Kong and China and other territory of China. So that is what we need immediately in short term if we can do it. Now, in UNCITRAL, we have now the discussion going on investment arbitration. And investment mediation is also coming up very well in that one. Many work you have done, former secretaries for justice. You have brought the UNCITRAL here, and the discussions are going on. But what is more required, that all the Hong Kong experts, now they should take part in those discussions. We have to come out with the Hong Kong proposal. We have to come out with the ideas, the Asian views. All these international organizations for last several years, ever since it was established, we are only negotiating on 2 drafts, either American draft or the EU draft. We never see a 3rd draft coming from Asia. And we want this one, whether it's UNCITRAL or WTO or any other organization, all these experts now have to come forward and bring the ideas, proposal, everything from Hong Kong, have an engaged discussion, and they take part in international rulemaking. If we do that, we can present the view of Hong Kong, and we can demonstrate how the one country, two system is working here, and international law and common law, how it is surviving here. We can tell them about that. So this is what I have to share with you. Thank you very much for your time. Thank you.
We're very grateful to Dr. Rajesh Sharma for reminding us of a number of very important points and principles. First of all, the need to regard Belt and Road as a vehicle which delivers the right to development. For too long in Hong Kong, because we live in a very prosperous and developed society, we don't appreciate how many challenges are faced by the developing world. And we should be reminded that our neighbor, India, is now the most populous nation on earth and will continue to be so for many years and decades to come. So the duty to help develop our neighbor, who has that duty? The duty obviously lies on more developed, more prosperous countries to help the less developed to reach the same level of prosperity. The reminder by Dr. Sharma that the road is not a territory, but actually a bridge, a communicator. And that is hugely important. The reminder that obviously Hong Kong's role is in dispute resolution, in which we are highly developed, both in arbitration and in mediation, and the need to extend the Singapore Convention to Hong Kong. So thank you very much, Dr. Sharma. I now have the pleasure of introducing our fourth and final speaker, Professor Kashif Imran Zadi, who is the Dean of the School of Law and Policy in the University of Management and Technology in Lahore, Pakistan, which is also a neighbor of our country. Professor Zadi.
First of all, I am very thankful to Professor Priscilla Leung for inviting for this wonderful event, wonderful place, and wonderful country. I was just reading One Country, Two System. And after visiting Hong Kong, it is my first, actually it is my, I was in mainland China for 3.5 years. But it was my first, it is my first trip to Hong Kong. And after visiting this city, I would love to say that it is a one city with dynamic multicultural angles, multicultural city. It is a one city with multiple cultures actually. And we can see here and we can observe every type of culture here, which is very much blessing and which is variety, and I think the people of Hong Kong are really lucky one to have a taste from all over the world actually. Secondly, I observed in the past that academic, no doubt, a lot of Pakistani people are working here, doing jobs, living here, and doing a lot of business activities. But it is also observed that academic collaboration was very less. And when I was planning to visit here, my president of the university specially asked to me that can we be the pioneer in Pakistan to have academic collaboration with Hong Kong? And I replied that it is actually now, if I am going there, it is academic collaboration which Hong Kong have firstly initiated. And I am that's why I am very thankful to Professor Priscilla, who have initiated and regard to the Pakistan academicians and institutions. Then we think that all the world, all the scenes, every development is for what purposes? State, constitutions, words, borders, limitations, systems, judiciary, legislature, security, for what purposes actually? These things are actually for the human development. Am I right, Professor Rajesh? Human development. The aim of every activity, every country, theme of every expert in every field is to serve the humanity. And I explain the One Belt, One Road, Belt and Road initiative is the actual thing which will serve the humanity, which will perform this actual theme for the world and people of developing and least developing countries. And we are very thankful to China, the People's Republic of China, who has taken this initiative actually for the well-being of the mankind actually. So about the basic theme and about the initial purposes and its benefits has been discussed by my mentor, Professor Rajesh. So I will move forward that where there is a lot of collaborations, when there is a lot of things happening together, obviously, when we talk about the mankind, human behavior, disputes are always there. Where there is collaboration, it is common thing. It is the nature of mankind. There must be some violation of the contract. Where there is a contract, obviously there will be a dispute. So I will focus with regard to the dispute settlements and opportunities with regard to the Belt and Road Initiative, and specifically with regard to China-Pakistan Economic Corridor. Can you please give me my first slide? Okay. Belt and Road Initiative, obviously, as Professor has explained, is an amazing project, amazing initiative by China. And the CPEC, China-Pakistan Economic Corridor, is one of the important elements of the Belt and Road Initiative. And it is going to connect, CPEC has its actually very geographical, very much important, because it is going to connect the Europe, Africa, and Asia together, and the work and the development of this project is very much speedy among the whole Belt and Road Initiative. So next slide, please. Belt and Road Initiative was launched in 2013, actually. And the President of the Republic of China planned to visit firstly for signing China-Pakistan Economic Corridor in the same year. But unluckily, due to the unstable situation, political situation in the country, he cancelled his visit in 2013, and ultimately CPEC was signed in 2014. But the arrangements for doing all these things was done in 2013, even in Pakistan. And it was the impact of CPEC that legal policies of Pakistan for foreign investors has been changed in 2013, and the Board of Investment and the government of Pakistan introduced Foreign Investment Policy 2013 for the protection and facilitation of foreign investors, especially keeping in view the concept of CPEC. And it provided different types of rights where people can invest and people can come and start his business, and people can come and do work. Chinese companies, corporations, individuals can come to and perform the idea of CPEC and implement this idea. Can you next slide? Okay. Impact of that policy, 2013, taken, and we can observe in this map that, in this data, that China became the top list at number 1 foreign investors in the Pakistan due to the privilege of CPEC. And Hong Kong is now, currently, it is the data from 2011-12 to actually 2021 till July this year. So Hong Kong is at number 4th, and China is at number 1 with regard to the foreign investment in Pakistan. And it is obviously, it is supporting the Pakistan in this tough situation, in this crucial situation, especially taking into consideration of infrastructure and energy crisis, which is the major problem of Pakistan nowadays. It is true that Pakistan has very important geographical place, and Pakistan has very important position in the world due to atomic power and other strong things. But it is also true that currently Pakistan have economic depression due to certain reasons, flood and like that, some political instability and like all these things. However, impact is that currently impact of BRI and CPEC, China-Pakistan Economic Corridor, China is at number 1 and Hong Kong is at number 4th from the world. Next, please. So I have mentioned the sectors, different sectors here: power, energy, trade, transportation, infrastructure, oil and gas. All these are textile even. So even if we have a writing pen and copy, currently it is from China right now. So Chinese investment and Chinese business has great importance in Pakistan. So next, please. This is the main, when you have such a massive investment and such a massive contract and such a trade and investment, so there are certain issues as well. And we have to see all these issues. Next, one by one. First issue is regarding the concession terms. Obviously, policies are there, and they have constituted a lot of things and given a lot of opportunities to the investors. But first issue is regarding the concession terms. And in this regard, the policies and parties must analyze the risks which are arising from the projects. Next. Secondly is relating to the conflicting priorities. In this way, both the parties and both the government first consider in terms of policy as to where commercial regulatory they can stand and negotiate the concession terms according to the situations and ground realities. Next. Financing terms is an important factor, and so issues with this regard are very much important, and the parties have to see and keeping in view include all transactions and securities and these various development projects, the terms and conditions where is going on, and because if the terms and conditions is not fulfilled, it will make trouble. So, with this regard and contracting terms and conditions, parties, both of the countries must make some policies and make some regulatory authorities so that things can be done. Next. Debts. Actually, you know that when the BRI has been started, a lot of things and question arises from the different nations, from the different countries, and same like Pakistani. The question was there whether it will be like East India Company, whether the Chinese will occupy this country, whether this investment will cause the damage to our sovereignty, because when the debt is basically a contract to give any debt, and the contract must be fulfilled. If the terms and conditions not fulfilled, there will be problem, and if the Pakistan or any country are unable to return back the debts, then what will happen actually? So it will also make trouble. So it is also issue, and both the government must consider this issue to consider the actual position in the country. Next. But one thing I want to tell you, that the quality which make the people satisfied, and especially to the legal experts, that in the white paper and in the documentation and theme of the Belt and Road Initiative, the government of China has implemented that during all the implementation of BRI, we will respect the sovereignty. And this is the cause people like me can defend easily in Pakistan this concept and BRI. Obviously, Pakistan is a common law country and China is a civil law country. And this two systems are different. So these varying legal and regulatory systems can make some trouble. So the authorities and governments and legal experts must take this into consideration and must consider that on the basis of all these issues, disputes can be happen. And if the disputes will not redress, obviously the whole idea becomes useless. So next. So keeping in view all this background and issues, if dispute happens, how to redress this? This is the main thing. Currently, both the governments have two official documents and agreements, which are leading all this trade, development, investment. One is BIT, Bilateral Investment Treaty, which is 1989. And second document is Free Trade FTA, Free Trade Agreement, which 2006 and taken into effect in 2007. When we observe these things, both these documents, we can observe that these both agreements do not fulfill the requirements for the settlement of international disputes. And both of the document have very narrow scope, which must be revised. It is compulsory for both the government to have some particular documentation for the settlement of disputes having scope, keeping in view the Belt and Road Initiative and China-Pakistan Economic Corridor. Can you please forward? Next, please. If only one BIT, Article 10, only one article is there which is explaining for the settlement of disputes, which covers only investor-state disputes, not others one. And the only two forums provided that. Very narrow scope here, unexplained. Competent authority for the settlement of dispute is court of the countries, obviously, which is not a good choice, having different system of law, having different cultures. And second is International Arbitral Tribunal. Only 3 words have been mentioned that if the parties want to have, they can join International Arbitral Tribunal. No explanation with regard to procedure, no explanation forum, and nothing anything. So it's having narrow scope and having only discussed about investor-state dispute, it doesn't fulfill the requirement of you may say China-Pakistan Economic Corridor and Belt and Road. Next, please. I know that it is a time of lunch, and a speaker who is especially before the lunch is considered a very wild. So I'm going to include very soon. So second, FTA. FTA is only talk about the investor-state dispute and nothing other, no trade dispute, no commercial disputes. So it makes no sense actually, and it is compulsory to revise this. So it also again court of the country. Forum, those 2 forums are provided here, like previous one, court of the country, and second one, exceed. Exceed may International Center for Settlement of Investment Dispute. It makes some more complicated. If the parties are from China and from Pakistan, and they have to go to exceed for settlement of dispute, which is not an easy task, and it makes some hurdles for both the parties. It makes, actually, it will reverse the idea of investment. Rather than investing and earning, people will investing and more investing on the settlement. So this must be some revision. Next. If I talk about the existing system, there are a lot of deficiencies. In this regard, China have taken a lead and established China International Commercial Court, CICC, and doing good, which is providing very variety of the settlement of dispute, mediation, arbitration, and litigation, outstanding thing. But it is only in China, having no jurisdiction in Pakistan. And if I talk about the Pakistani existing system, a lot of problem is there. Old law, outdated laws, delay, judicial activism, procedural framework, corruption, and lack of modern technology. So these are deficiencies, and we cannot, and the CPEC disputes cannot be settled with this. Can you please go forward? Next, please. So keeping in all views, I have suggested something for both the countries, and I hope it is very workable idea, and academician can only suggest the things, and it is the part of the government. Both of the government should establish alternative dispute resolution mechanism, which should include arbitration, mediation, and negotiation. In this way, when the special mechanism and special centers will be established in Pakistan and China, and even including Hong Kong, because Hong Kong is a part of China. So, if special centers will be established, which will settle the disputes through negotiation, arbitration, and mediation, things will be good. And it will be smooth. So it is my first suggestion. Second one, next. For this purpose, they have to do some agreements and understandings, MOUs, and furthermore treaties. And after that, data platform on legal issues, that they must establish a platform where both the countries have their legal issues. Data of the parties must be there so they can settle the problems. Next, please. And last one is trust of the locals. Actually, when the policies were made, in future, government should make some agreements and they should deal with these things. They should consider the they should consider the ideas, they should consider the suggestions of both the local businessmen, community, legal experts, and all that. In this way, they will have a very wonderful solution of the disputes which will arise from China-Pakistan economic corridor. I am very thankful to all of you for bearing me for such a long time at the time of dinner. Thank you so much.
We're very grateful to Professor Zadi for using his country, Pakistan, and his relationship with China as a microcosm to address many problems that no doubt the rolling out of the Belt and Road Initiative will face. We're very grateful for solutions offered, and may I suggest one point which might be hopeful and optimistic. I think Professor Zadi reminds us that China is, of course, a civil law jurisdiction. Pakistan is a common law jurisdiction. The dialogue is not that smooth, but of course Hong Kong, which is part of China, is a common law jurisdiction. So Hong Kong can be the bridge in resolving the dispute, and that is the role I think we can valuably play. Thank you very much, and thank you everybody for listening. Well, I think we're very grateful for everybody participating in this last session before lunch, and I know we are keeping you from your food and sustenance, so I will end this session now, and thank you once again for your valuable participation.
Thank you again for this tour around, taking us all the way from commercial arbitration to investor-state treaties and beyond. Could this guest stay behind quickly for presentation of souvenirs?
好啦，呢個時間呢，我哋都多謝我哋咁多位嘅講者。邀請呢，我哋而家邀請陳弘毅教授同埋馮華健資深大律師呢，係為我哋呢頒發一個嘅感謝狀同埋紀念品俾我哋咁多位嘅主講嘉賓嘅。咁我哋有請陳弘毅教授同埋馮華健資深大律師嚟到台前，為我哋咧將呢一個嘅感謝狀呢係逐一頒發俾我哋各位嘅講者。咁我哋首先有請 Dr. Rajesh Sharma。好，我哋一齊影張相啊！
Next up, can we have Professor Zadi?
咁我哋請陳弘毅教授同埋 Professor Zadi， 我哋一齊影一張嘅合照。So may I invite Professor Chan and also Professor Zadi to take a group photo. .我哋都邀請埋梁博士一齊嚟到台上。好 好，我哋不如影張合照先啦，好嘛？好，我哋4位一齊影張合照。亦都非常之感謝我哋咁多位嘅主講嘉賓呢，佢哋寶貴嘅時間同我哋分享嘅，多謝晒。咁然之後呢，我哋都有請袁國強大紫荊婚宴接受一個嘅感謝狀。我哋都請梁博士，我哋一齊影張嘅合照，亦都邀請埋馮華健資深大律師，我哋4位一齊影一張啦。好，都再次咧邀請咁多位嘅講者嚟到台前，我哋仲有一本嘅著作咧，想送俾咁多位嘅。Maybe invite all the speakers to come up in front of the stage, and we have a book want to share with you. 亦都多謝咧喺線上同我哋分享嘅黃貴國教授嘅。咁而家咧，我哋送緊嘅呢本著作咧，就係由黃貴國教授所寫嘅《中華傳統文化視角下的國際經濟法》。咁希望呢，都藉此著作咧，可以同我哋咁多位嘅專家學者一齊分享。
The book being presented is a book authored by Professor Wang on international economic law under Chinese culture and influences. 好，咁大家可以靠得親密少少。And may I invite speakers to have your book and also the certificate on hand, and let's take a group photo. 好，咁多位可以望望我哋中間嘅大會攝影師啦。大家咧都攞住著作啦，同埋我哋嘅紀念狀，我哋一齊影一張嘅合照。我哋再一次俾掌聲，我哋第二個環節嘅咁多位分享嘉賓同埋我哋2位嘅主持，多謝晒咁多位。咁隨住我哋第二個環節嘅論壇結束，亦都進入我哋而家一個 lunch break 嘅時間啦。咁我哋呢個午休時間呢，會去到下晝嘅2點鐘。咁我哋下午嘅環節會喺2點鐘再一次喺呢一個同樣嘅地方開始嘅。而獲邀去午宴嘅嘉賓呢，而家可以移步到去旁邊我哋嘅 ballroom 4嗰度。咁我哋嘅午宴亦都準備好㗎啦。咁我哋陣間2點鐘再見。 There will be a break until 2 p.m. The invited guests for lunch could go to ballroom 4.